Hello, everyone, and welcome back to Uncivil Law, where we learn through the misfortunes of others. As always, I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court, in our continuing coverage of the impeachment trial of one Ken Paxton, the elected Attorney General, who may or may not have turned over his offices to the benefit of one man, Nate Paul, a real estate developer in Austin, who was having some troubling times, and also was alleging a grand conspiracy that would have implicated both judicial and executive branches in acting in concert against him. And it was kind of weird. And so the Attorney General got involved in a personal way and may have corrupted his office, as we're trying to here to determine. Also, may have retaliated against them illegally for being whistleblowers, as opposed to firing them or otherwise disciplining them for some sort of bona fide reason. The real reason that he fired them was because they're whistleblowers, or so the allegation goes. We have begun to hear from the defense case. The defense case so far has focused on the creation of the report relating to the whistleblowers and whether it was generated properly, and the defense has made some good points to show that it wasn't created unlawfully or improperly, and the person who was responsible for generating it didn't have undue pressure put on him to create it, and he created it, because he thought it was right, and the rest of it, and that they pursued things and they tried to show like lies and misstatements, but they didn't really work. And then he had the snarky, the person who's cross-examining her, or the woman who's cross-examining him, had the snarky line at the end that the AG's office took the position they weren't subject to the ethics rules. And then we looked up what the Attorney General actually wrote, and it wasn't that. So, yeah. So that is where we are. And all that. Culperistic says, what kind of evidence could they give that would explain the actions against the whistleblower that would make you believe he didn't do it for that reason? I don't know I don't know in the abstract what that would look like. I suppose it would look like, I don't know. I don't know what that would look like right now. I mean, they have to rebut the case that it was for a non-protected reason. So I suppose that they could try to lay out the reasons that they took. They could try to lay out steps they took other than that. If they could show with respect to each of the whistleblowers like a pattern of disciplinary action that precedes the FBI investigation, so that they can show that like this was just another step along the path. So they took actions against them, because they were, insert any other reason other than them being whistleblowers, and that the actions they took after whistleblowers was just because it was another step another step along the same lines. That would be helpful if they could show, some sort of standardized disciplinary process they typically use, and they can show the objective reasons and show when those disciplinary processes would or would not be used in an objective way. So if they have some sort of process in place where they discipline employees because of X reasons, and they can show that they typically discipline employees for X reasons, and this was just another case that was similar to all those cases, that would probably help. So if they can show through the pattern of conduct as it relates to either these people or as it relates to them just being another person like anyone else, then that would help to show that it wasn't being done because they're whistleblowers, that they are not the specials. It would go a long way to obviating the idea that they did it because they were whistleblowers. So, yeah. For all 8 of them, that would be helpful, ideally. The more of them that they can knock out, the more it would be helpful to Paxton, because the thing that is the problem is, or at least a thing that's a problem, is the fact that it seems difficult to believe in the first instance that all 8 were disciplined for good reasons. So if you're able to eliminate all 8, that would be great. If you're able to reduce that count, that may be sufficient. Because if you're left with an insufficient number, that you can be like, well, 5 out of them maybe, are cleared and the rest of the 3 are ambiguous, then on a beyond a reasonable doubt standard, you'd be like, well, maybe there's not enough here to prove it. So I don't know that you necessarily need all 8, but it would be helpful. Anything that knocks out your support would be nice. Is sending the grand jury subpoenas to a personal lawyer actually an issue? Yes. It violates the confidentiality of the grand jury subpoenas. It's a problem. The grand jury subpoenas are secret. They shouldn't be sent to anyone that are not authorized to receive them. So I think that that's a problem, yes. It was evidence of a criminal act or something. It's a problem. It's not good. It's a problem. Sandy says the group gossipy chat was good, but didn't go quite enough to prove maliciousness. So you need something stronger to prove these people acted hastily and not in good faith. Yeah. Being hasty doesn't necessarily preclude it from being a good faith. Good faith doesn't, again, like if you're thinking about it by comparison to calling 911, it can be extremely hasty. Being hasty doesn't necessarily preclude it being in good faith. It's just, do you think that there's prima facie evidence of a problem? And they seem to have more than, although the ultimate decision was somewhat hasty, they seem to have months building up to it. So I think that that is better. Kate says, what if Paxton fired them because they didn't follow orders and wouldn't question the feds? Well, if he did it because of those reasons, then that's probably okay. Or more the point, it would be okay. Then in that case, he'd be firing them because they're insubordinate. And he wouldn't be firing them because they're whistleblowers. So if you fire them because they didn't follow his orders, then that would be fine. But then the question is, why did he fire them? What is good faith in this context? What would need to show their actions were non-good faith? To show their actions are non-good faith, you'd either need to establish that there was no basis for them to believe a crime was occurring, or you need to establish that they went to the FBI to provide cover for themselves so they wouldn't get fired. So what is their motivation for reporting it? And they were using it as a shield, because they wouldn't have made the report but for the fact they were using the shield to benefit themselves, would be bad faith. Voiding warranty says, I'm disappointed with the prosecution. Their case seems weak overall and disjointed. Okay, you're entitled to your opinion. Fair enough. There are certainly various charges that have not been proven and are weak. So I'll certainly agree with you in part. Do I think grand juries should be secret? Yes. Grand juries are poorly named in my view as to what they are. Grand juries have always been secret. They're an investigation tool. I think grand juries are just badly named, and we're just kind of stuck with the name. At least in the state system, a lot of their functions have been taken out of the grand jury system and given to other apparatuses. About half the states don't use them. I think every state has it on the books, but about half the states don't use them. Half the states use them sometimes. The purpose of the grand jury is an investigation tool. So a lot of what grand juries do has been given off to police. So in the same way that an investigation by the police is secret, grand juries are secret. It's just an investigation being conducted within the judicial branch as opposed to the executive branch. It's a bit of a historical holdover. But, so yeah, for the same reasons you'd hold a police investigation secret, grand juries are secret for the exact same reason. $10 from England DJ. Wanted to say you have some of the best hold music choices. I was jamming out to your music you chose for the end of the other stream. Very cool. I appreciate it. Culper said, I think if you looked at the summary of what Carmack testified, you would see the evidence he laid out to be certain on a few counts. Yeah, I think he laid out pretty good evidence as to count 5 with respect to him being hired, and also count 1 for that matter. With respect to MIDI, although more on count 5. But yeah, I found Brian Kamek to be very credible as a witness. He's not a whistleblower. He worked directly for the AG, direct report, talked to the AG. The AG's involvement is obvious. And then, of course, you have Nate Paul's lawyer, who's also extremely heavily involved with Kamek, providing a list of names of the people to be subpoenaed, which is just an enemy's list of Nate Paul. So that's really bad. What's the difference between a special grand jury and a regular one? Special grand juries are called for the specific case in specific case. That's the only difference. Grand juries typically sit for very lengthy periods of times. Grand juries, depending on your jurisdiction, but grand jury sits for months and sometimes longer. They'll sit for like a year and a half, and they'll just hear case after case after case after case after case. So like they're just there like for months hearing all kinds of cases. So all a special grand jury is a grand jury that's been called to hear a specific case, and that's it. There's otherwise no difference between them. Prosecution female who went second is playing fast and loose today. She hasn't been as sharp today as she was the other day. That's fair. Have I ever done jury duty? No. I got called for jury duty once, but they settled at the last minute, so no one got to be seated, so I was very disappointed. So I got to see the crappy video that, every juror sees. The crappy video will depend on your jurisdiction, but it's the same exact goddamn video in substance, Congratulations on being here for jury duty. Your role is important, and you know the video. You know exactly what it says. You know, we appreciate your help. Blah 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 blah. It's like, could I do a short summary for each day? No. That would require me going back and like listening to each day. I've been pulling some long days as it is. These are hard on Uncivil. What's my opinion on jury nullification? It's hard to have an opinion because, like any tool, it could be used for good or bad. And yeah, I don't know that I can. Is it worth the cost of it? I don't know. I honestly haven't thought about it in like super in depth to think about it from first principles, whether or not it would be worth the cost of doing it. Maine tried to adopt it. I think it got struck down by their Supreme Court, though. I forget how that resolved, but Maine tried to put jury nullification into their rules. So I'd have to go check to see how that finished out. Your only jury duty didn't have video? Oh, God bless you. There wasn't a video that you had to watch on your congratulations of jury service? You lucked out, man. You lucked out hard. Yeah, we'll be ending today at 6 p.m. or 6:15, give or take, today. So we might get this interrupted, so we'll see. Right-wing extremist says federal agents are falsifying warrants. It wasn't just federal agents. It would have required like the FBI and two different assistant U.S. attorneys, and the federal magistrate. And it's like, it's just too much. It's just too much. It's just too much. It's ridiculous. You know, stranger things I suppose have happened. The absurd sometimes happens, but like, I'm gonna want some real proof, and like, it seems absurd. You know, it just seems ridiculous. You sat on a federal grand jury for 18 months. There you go. So, yeah. 2 people can barely keep a secret. Yeah, that's right. So, and also, of course, at the risk of pointing out the obvious, the federal magistrate is a member of the judicial branch, and the U.S. attorney and the FBI is a member of the executive branch. So it would be cross branches of government conspiracy. It's like, like, you know. And also, like, there's very little reason to do it. In fact, like, why would you do it is like, why would you try to change the warrant for one thing into a warrant for different? It's just weird, right? It's like, it's just a very weird thing. Things like that have happened before, probably, but it's a pretty absurd tale, right? I mean, you know, a guy comes into you and, you know, and tells you something that seems pretty exceptional. You know, you're gonna want a little bit more before you just, you know, run off on a complete wild goose chase. You know, although to the Attorney General's credit, for what it's worth, as we've discussed before, if the Attorney General did this because he's just an idiot, it's probably legal. So if the Attorney General did it because somehow Nate Paul is just that good and got the riz, and somehow got the Attorney General to basically, you know, become a complete moron, if he really believed it, then he's probably in the clear. So there's that. It doesn't particularly help that everyone in his staff was telling him, no, this is complete stupid. It's like, when you have everyone on your staff telling you this is a complete stupid. It's like, it goes a long way to being a problem, but yeah. I am not an expert on the prosecution of Al Capone, so I'll have to defer on that piece of history. Sandy says Papadou is a great date restaurant. I'll keep that in mind for the future. Papadou is mid at best. That's funny. England DJ says, I love your analysis and thanks for covering it. I've been learning a lot. No problem. The USA is like only one of 3 countries that uses grand juries. So we're in an anachronistic holdover. We learned it from you, UK, and then you guys abandoned it. So it's a little anachronistic, but you know. TX Joe says, why do you think it happens? Seeing 1A auditors get jammed with shenanigans constantly. Well, in those cases, you have evidence of it happening. Also, it's shenanigans usually by a police officer. Or the police officers that happen to be there at the time. I don't really know, but maybe I'm not paying attention. I'm not really aware of grand conspiracies against the 1A auditors. Usually it's like a police officer who kind of goes off the reservation and does the stupid. So, but a grand conspiracy, that's harder to fathom. What are the 2 other countries? Don't ask me questions like that. That's not fair. I think Libya is one of them, but I don't know. Liberia? Was it Liberia rather than Libya? It's one of the L countries. There you go. It's one of the L countries. Problem with the judiciary is there's no one to check them. Well, that's what appeals are for. But, and to some degree, there's the political role because, of course, the political branches have power to get rid of individual judges if they're truly corrupt. But, by the time you become a judge, for the most part, you've been pretty vetted. So it's kind of unusual. FN Fear No Stigma says, I find it odd the prosecution against Paxton didn't prove Paul's theory was wrong, as evidence that it was actually obstruction of justice seems like it would be easy. Whether Paul's theory was correct or not isn't necessarily the relevant issue. Because it goes to this idea that you can't just luck into a defense. It goes to what you know at the time, not the ultimate truth of it. So to give you an example, from self-defense land, to give you an example where this would be true, let's suppose that you shoot a guy in what you say is self-defense, and it turns out after the fact that the guy did in fact have a firearm on him, and he was planning to kill you, but you didn't know that. You just shot him because you thought it would be fun to do or something. You shot him because it would be fun to do. As it turns out, after the fact, it turned out he had evidence and, he had a piece of paper in his pocket.
The party, sorry, we're a little late. We had some business to take care of back there.
Right. You can't luck yourself into the self-defense argument. So what matters is your knowledge, not the ultimate truth of it. You can't luck into it. And that also goes the other way, by the way, for the prosecution. Like, if the guy had what appeared to be a gun and he was threatening you, but, you know, he had a note in his pocket like, this is just a prank, bro. Right? Which we covered that case. We've covered that case. Yeah. The guy has a note in his pocket. It's just a prank, bro, but you don't know that. So your self-defense is righteous, even though he wasn't really trying to kill you, but you didn't know that. So the truth of it isn't what matters. What matters is your knowledge and perceptions, not the ultimate truth in the reality. We covered that case with a YouTuber. What a stupid guy that was. Two YouTubers decide, you know what they're going to do for clout? They're going to fake.
Would you please state your name for the record?
Knives.
Yes, Your Honor. Amy Hilton for the Attorney General.
Would you call your first witness?
These
Yes,
two
Your Honor.
YouTubers,
The Attorney General calls Henry De La Garza.
Will the bailiff bring in Henry De La Garza?
these two YouTubers decide they're going to fake an armed robbery. So they take knives
Amy,
and they go to this kitty,
still up here if you want to get
you know, place where like there's ball pits and stuff. It's a professional business where, you know, kids go play. And they go into the place and they fake an armed robbery. And a guy there has a gun and shoots and kills one of them. Well, it's just a prank, bro. Yeah, but it looked real to him. So that's a righteous shoot. So, yeah, we've covered that case too. You don't have to be right in fact.
Watch your step. Need to swear you in. Raise your right hand. I do solemnly swear or affirm that the evidence I give upon the hearing of the Senate of Texas of the impeachment charges against Warren Kenneth Paxton Jr. shall be the whole truth. Shall be the truth, the whole truth, and nothing but the truth, so help me God. I do.
Thank you for the note.
Speak closely to the microphone.
I was trying to get his name spelling. Thank you, Sandy. Sandy gets a bonus point for helping
Hold on,
with the spelling.
I understand we have a new court reporter I need to swear in also. Where is our new court reporter?
She's down there.
You raise your right hand, step to the side. Hi. I do solemnly swear or affirm that I will correctly transcribe and report all the proceedings of the trial of Warren Kenneth Paxton Jr. Only impeachment, so help me God. Welcome. Give her a moment, and then when you see she's ready, proceed.
Yes. Good afternoon, Mr. De La Garza. Could you please introduce yourself to the jury?
Yeah, turn on the mic. It's another day with another microphone.
Yes. My name is Henry De La Garza.
And I'd like to just have you take a minute and a half or so and give us a little of your background, where you're employed, and what you do there.
I work at the Office of the Attorney General, an agency of the state of Texas, and I am the HR Director, the Chief Employment Counsel, and the Ethics Advisor.
And how long have you held the position as HR Director?
Of HR Director, Interim Director, November 2nd of 2020, and then became permanent HR Director December 1st of 2020.
How long have you worked
good,
for
he's
the
HR
Office of
Director.
Attorney General?
Oh, joy.
I started in 1995 as an Assistant Attorney General 1 and worked my way up.
And what division did you start in? Have you always been in human resources?
No, I started in Habeas Corpus Division and then went to Transportation Division and then Human Resources.
It sounds like you were demoted.
How many attorneys general have you worked for at the
You went
agency?
from habeas corpus to HR?
Well, let's see.
Are you any good at your job,
Dan
sir?
Morales, and then John Cornyn, now Senator Cornyn, Greg Abbott, now Governor Greg Abbott, and then Ken Paxton, and then also the provisional AG John Scott and provisional AG Angela Colmenero.
How many years have you been working in human resources?
I started in May of 2008.
You've testified that you've been at the agency for a couple of decades. How would you describe your experience working at the Office of Attorney General?
The agency is an outstanding state agency. It's a great place to
Wow, he's the head
work.
of HR and thinks the agency's
This is
awesome. What a shock.
As a lawyer, it's an ideal place to practice law, whether you do civil.
But you're not a
criminal,
lawyer, or at least you're not
trial,
acting as one.
appellate, transactional.
You went from habeas
plaintiff's
to
defense,
HR.
whatever. We have it, and as an agency, we're number one in child support enforcement. This is an agency of lawyers, of child support officers, peace officers, and a lot of hardworking employees.
And as the HR director, how many employees at the Office of Attorney General are you responsible for, enforcing agency policy and procedure?
Well, the approximately 4,000 employees that we have throughout the state of Texas. And we also handle human resources work for the State Office of Risk Management, SORM.
And just generally, what are your responsibilities as both the ethics advisor, the HR director, and the chief employment counsel?
Well, it's quite a bit. As HR director, I oversee the HR operations for our state agency, 4,000 employees throughout the state of Texas. I lead a team of 22 talented and dedicated employees. We handle all sorts of HR functions, from hiring, posting, classifications, onboarding, benefits, leave, training, development. We have a wonderful wellness program, and we also have a robust law clerk program. And as Chief Employment Counsel, I, along with the other attorney in the division, excellent Deputy Chief, we provide legal guidance to the managers and supervisors of the agency, and we, make sure, EEO compliance, the rare EEOC charge of discrimination, and workers' compensation, and unemployment benefits. And then as ethics advisor, I provide guidance to approximately 700 lawyers of our agency, mostly on the Texas disciplinary rules of professional conduct, other ethical issues. And then
he's the guy who does ethics advice
fraud,
too?
waste, and abuse prevention program.
Okay,
I
that
think I had it all.
seems a little sus.
I started as a law
I'm not
clerk
sure
at the
why,
office,
but
and
I
so
don't really
I certainly
like that
appreciate
combo.
everything that you
Head
do
of
for the office.
HR and also the guy who provides
Outside
ethics
of working
advice.
in HR, do you have any other experience with
Something
employment
about that
law?
just sounds wrong.
Yes, before starting in HR, I worked in the transportation division where I managed the employment law matters for TxDOT, another outstanding state agency, and handled the trials, appeals, hearings for state and federal law, for all different types of employment laws. Title VII, Chapter 21 of the Labor Code, FMLA, FLSA, ADA, First Amendment retaliation, whistleblower retaliation, USERO retaliation, workers' comp retaliation, all that.
And so you mentioned the Whistleblower Act. Have you ever taken a Whistleblower Act case to trial?
I actually have.
Okay. And does the Whistleblower Act, does that have certain requirements in order to state a claim?
It does.
And does it also provide specific remedies?
It does.
Is one of those remedies removal from office?
That's a
It's
bullshit
not.
question.
And who is a proper defendant under the Texas Whistleblower Act?
The government entity.
Is an elected official a proper defendant under the Texas Whistleblower Act?
No.
Where are Whistleblower Act claims usually adjudicated?
It's a state law claim, so it would be in state district court.
Are you aware of a Whistleblower Act claim ever being litigated outside of the state district court?
Not under the Texas Whistleblower Act.
Are you aware, Mr. De La Garza, that in 2020, a group of high-level staffers made reports to law enforcement
That is
about
the
the
most
Attorney
bullshit
General?
question in this context.
And are you aware that some of those staffers subsequently filed a Texas Whistleblower Act lawsuit against the Office of Attorney General?
I am.
And to your knowledge, is that case still pending?
Yes, in Travis County.
You mentioned that you've worked under a number of attorneys general, and so I just want to ask you a few brief questions about how the agency works. How do most employees of the Office of Attorney General obtain their positions?
Most employees, I mean, we're talking about, just about everyone, would apply through a competitive posting, and then the hiring manager would select the best qualified candidate.
And how did the former staffers who made those complaints to law enforcement, how did they obtain their positions?
They were appointed by Attorney General Ken Paxton.
And so, and to be clear, I think you said there are about 4,000 OAG employees?
Yes, about 4,000.
And about how many are appointed?
We're talking about half of 1%, maybe 0.2% or 0.02%.
Those are three very different numbers.
Is it your understanding, Mr. De La Garza, that the Attorney General has authority to appoint certain high-level policymakers?
Yes.
And what is that understanding based on?
Well, it's a well-established concept and tradition in the United States of political patronage. This has been affirmed in Supreme Court law, U.S. Supreme Court law, federal law, state law, that elected officials, whether you are the governor or the attorney general or the elected sheriff of a county, that you have the right to hand select people who are going to help you.
How does that help the AG?
Reach the goals and the vision that you presented to the electorate, and
how's that helpful?
Voted you in.
And
is it because they're going to be
for those appointed officials,
because they're political, they can just
at
be
the
removed
Office of Attorney General, are those appointed officials still required to comply with agency policies, just like every other OAG employee?
Yes.
At this time, Your Honor, I'm going to move to admit Attorney General Exhibit 431. Counsel and I discussed this during the break, and I understand that there is no objection.
No objection.
Admit AG 431 into evidence.
Mr. Arroyo, could you please pull up AG 431? And could you turn to the second page, please, Mr. Arroyo?
What a dumb question that is.
Mr. De La Garza, is Exhibit 431, do you recognize this as a copy of OAG policies and procedures?
On the screen, there's nothing on the screen.
Oh.
Hold on one moment.
I've done many whistleblower complaints, and I can tell you in my vast experience, this wasn't a valid whistleblower complaint. These people were just bitter. All right, sell me. As the head of HR and head of ethics, I determined they were ethically wrong, and this wasn't valid whistleblower, and so I gave Paxton the all clear. I've never seen a more righteous firing in all my days. Ken Paxton is the best boss ever. He wouldn't do anything wrong, wouldn't hurt a fly. And maybe it's just me, but I find this guy a little smarmy. Not super inclined to believe every word coming out of his mouth. Maybe that's a little unfair, but then again, I am judging the witness based literally on his demeanor on the stand. So, there's that. He doesn't inspire in me a lot of feeling of, oh yeah, this guy's just here to tell me the truth, the whole truth, and nothing but the truth. This guy's in here to shade the facts at all. He's just here to tell me the truth, and he's a reliable and completely objective witness. I'm not getting warm, fuzzy feelings. Are you a puppet, sir? How deep is Ken Paxton's hand up your ass right now? I object to this witness being called to the stand at this time. This is clearly just Ken Paxton testifying, but it's not Ken Paxton on the stand. He's obviously a mouthpiece for someone else. His words are not his own. Move to disqualify. Yeah, and I feel like that cuts the other way with the whole, like, he handpicked these guys. That kind of cuts the other way for me, right? Ken Paxton personally handpicked these guys. And they all are what? What are we saying? In Ken Paxton's framework. They all were, just bastards who were trying to engage in a coup. I mean, not to put too fine a point on it, but what does that say about Ken Paxton's ability to hire people? If Ken Paxton personally, directly, himself is hiring these people, and all these people are a bunch of horrible betrayer, conspirator, whatever, Ken Paxton isn't very good at hiring people, is he? So maybe we should fire him for that incompetence. Ken Paxton sucks at hiring people. Same thing happened to Trump. Yes, it did. Trump also not necessarily the best at hiring people.
Members, return to your seats, please.
So,
Hold on 1 second, Amy.
Yeah.
You start the clock again. Proceed.
Mr. De La Garza, can you see Attorney General Exhibit 431 on your screen?
Yes.
And you recognize that as a copy of the Attorney General Office of Attorney General Policies and Procedures?
Manual? Yes.
And what is your role, if any, with respect to drafting and creating policies for the office?
Well, since May 2008, I've been pretty active in making sure that our policies are up to date, revising policies with new laws. For example, I know that we've got the new Crown Act and military performance and paid parental leave, things like that. So we make sure that we're always keeping up, and we make changes to the manual.
Do these policies provide that Office of the Attorney General employees are at-will employees?
Yes.
And can you just briefly explain what that means?
Well, the state of Texas is an at-will state since, I think, 1877 or something like that. And it just means that in Texas, you don't have a property right in their job, you can be fired for any reason. A little more? This? Oh. Oh, perfect, thank you. Thank you.
Mr. De La Garza, are members of the executive administration at-will employees?
Yes.
Does OAG have an unacceptable conduct policy?
Yes.
Mr. Arroyo, could you please flip to page 43 of Exhibit 431? At the bottom, the bait stamp should end in 535.
You can fire him for any reason. Well, it's not quite right, counselor. I feel bad calling him counselor.
Mr. De La Garza, is this the unacceptable conduct policy we were just talking about?
Yes.
And Mr. Arroyo, if you could just flip to the next page, please. And about halfway down on those bullet points, Mr. De La Garza, one of the things that's listed as unacceptable conduct is use of an insubordinate or unprofessional tone towards management. Do you see that?
Yes.
Is that a policy that you wrote?
Yes.
And when did you write that policy?
Based on the date that I saw, it looked like it was in 2013.
And can you explain for the jury why you included that policy in the office's policies and procedures handbook?
It just seems typical that most manuals for employers would include something about, conduct and what's appropriate and what's not.
What are the potential consequences for failing to comply with agency policies?
Well, it depends. We look at every situation individually. It could be corrective action, such as a counseling session, a reprimand. But if it's, depending on the situation, it could be disciplinary action, including involuntary separation.
As the Chief Employment Counsel, the Ethics Advisor, the Director of Human Resources, do you provide advice to executive management on matters on employment issues?
I do.
And do you provide advice related to the application of the policies that are contained in AG Exhibit 431?
I do.
I'd like to switch gears a
I'm
little
sure
bit
you
here,
have all
Mr. De La
sorts of
Garza,
fun
and talk
and interesting
about
policies in your
the
manual
ex-staffers, the
that
former
could hypothetically
staffers,
apply to these people.
that left the Office of Attorney General in 2020. Who was Jeff Mateer?
Jeff Mateer was the first
Amazingly
Assistant
enough,
Attorney
I
General.
am
And
sure
how did
your
his
HR
employment at the
manual
OAG conclude?
has all kinds of fun latitude
Jeff
to protect
Mateer
management.
resigned on October 2nd, 2020.
And who succeeded him as first assistant?
Because Jeff Mateer resigned and Attorney General Ken Paxton had, a right to then select someone, and under the Texas Government Code, every state agency needs to have an executive head, and at the Attorney General's office, that executive head is the first assistant, and so they pretty much manage the division day to day, and so Attorney General Paxton appointed Brent Webster, and then he began that same Monday, I believe, October 5th, 2020.
At the time that Mr. Mateer resigned, were the other former staffers still employed at Office of Attorney General?
Yes.
And so at that time, they reported to Mr. Webster, is that right?
Yes. Starting on October 5th, 2020, they would have been reporting to First
I already
Assistant
know where
Brent
this
Webster.
is going, and I already don't
And
like
would
it.
those staffers be required to comport with OAG policies in their interactions and their work for First Assistant Webster?
Yes.
And
I
that
know
would be a
exactly
reasonable
where this is going.
expectation that Mr. Webster would have of them.
Yes.
He was insubordinate.
Let's talk
with
about
Mr.
Ryan
Webster.
Banger. Do you recall what his title
He
was?
used a mean tone. That's the reason
Ryan
we
Banger
fired him.
was the Deputy First Assistant Attorney General.
And how did his employment at OAG conclude?
Mr. Banger submitted a letter of resignation on approximately, I think it was October 28th, 2020, and then left the agency as identified in the letter on November 4th, 2020.
And what about Darren McCarty? How did his employment at OAG conclude?
Darren McCarty was the Deputy Attorney General for Civil Litigation, and Mr. McCarty submitted a letter of resignation on, I believe, October 26th, 2020, and then left the agency pursuant to the letter he left on November 4th, 2020.
And what about Blake Brickman? Do you remember his title?
Mr. Brickman was Deputy Attorney General for Policy and Strategy.
And
Well,
how did
guys,
his
at least for me,
employment
we
at
have
the
found
office
it. We have
conclude?
found the witness that I believe the least.
Brickman was involuntary.
I don't believe one word coming out of this guy's mouth.
Mr. Arroyo, could you please pull up AG Exhibit 224? And Your Honor, I'm going to move to admit this exhibit. I understand from counsel during the break that there is no objection.
No objection.
He's self-serving, smarmy,
It should
aggrandizing.
be, what was the number again?
AG 224.
224, admitted to evidence.
I'll take my chances with a
Mr.
used
De La
car
Garza,
salesman over this guy.
Memo a memo that you drafted related to Mr. Brickman's employment with the Attorney General's office?
Yes.
And does this memo reflect advice that you provided to the office related to Mr. Brickman's continued employment and ultimate termination?
Yes, it was advice about if we wanted to write a justification, this could be a draft of a justification.
And is
You
this
went in
justification,
search
was
of a
this the result
justification,
of an
didn't you?
independent analysis that you made with respect to his employment at the office?
Yes.
Were you instructed by anybody to come to any conclusions regarding his employment?
No.
Could you please explain the conclusion of this memo for the jury?
I only see page 1. I'm not sure if...
Your Honor, may I approach the witness, please, with a hard copy?
Yes, you may.
Thank you. Just the conclusion was that involuntary separation, that he could be allowed to resign.
Looking at the memo, at the bottom of page 1, you write that Mr. Brickman has engaged in the following misconduct as identified in the agency's unacceptable conduct policy. Do you see that?
Yes.
And you list a number of violations. Is that correct?
Yes.
And is it true that in this memo you indicate that regardless of Mr. Brickman's report to law enforcement, there are violations of agency policy that justify termination?
Yes. I mean, in many ways, it's just it was a situation of an employee with a new boss and having an insubordinate or unprofessional tone towards the new boss, and
Really? Brand new employee, brand new boss, a
not
little insubordinate,
following
you go
orders,
immediately to
directives
let's
of the
fire
new
the guy.
boss.
Wow. That seems kind of
based
aggressive.
on the information that you were aware of at the time, was it your opinion that Mr. Brickman's had some job performance issues in the workplace following his report to law enforcement?
Yes.
And was part of that misconduct creating an atmosphere that was untenable for the agency?
Yes.
And can you just describe a little bit what that is? I'm looking at page 2 of your memo, talking about the working relationship being strained and inefficient. Could you describe what you were aware of at the time that you made this memo?
Yes, I mean, overall, it appeared that there were some pretty egregious violations of the, kind of the insubordinate tone of that policy that you had mentioned earlier. And the insubordinate tone, the demeanor, the language, the refusal to perform directives from the Mr. Brickman's new boss, new supervisor. Just overall, there were those issues.
Brand
really
new supervisor.
And then overall,
Insubordinate
just
tone.
based
Let's
on
fire the guy. Sure.
Everything.
Sure.
Applicable state law, federal law, the facts presented. There was no reasonable expectation that he wanted to work for the new boss, the new first assistant, or no reasonable expectation that.
Objection. Narrative. We just asked for a question and answer, Your Honor.
Sustained.
Mr. De La Garza, you mentioned that Mr. Brickman's behavior was egregious. Did I hear that correctly?
Yes.
And is it your understanding that part of the egregious nature of his behavior was his refusal to meet with his supervisors?
Objection. Leading.
I'll rephrase.
Rephrase. Sustained.
Mr. De La Garza, what was egregious about Mr. Brickman's behavior?
I mean, based on the facts presented to me, that type of insubordinate tone and demeanor is pretty rare in our agency.
Who did you provide this memo to?
Bullshit.
I believe I would have probably sent it to my boss at the time, the human resource director at the time, and
Really, his
probably
tone was
Brent
so
Webster, the
vile,
first assistant.
so bad.
To your understanding, who made the decision to terminate Mr. Brickman's employment?
It would have been, his supervisor was the first assistant.
And did you support the decision to terminate Mr. Brickman's employment?
I mean, based on the facts as presented to me and the applicable state law and federal law, especially about political patronage, yes, there didn't seem to be a reasonable expectation that he could continue working with or for Brent Webster or continue serving as a high-level policymaker for the Attorney General.
And do you stand by the advice in this memo today?
I do.
Sure.
Okay, let's talk about Mr. Ryan Vassar. Was he the Deputy Attorney General for Legal Counsel?
Yes.
And his employment at the office was terminated, is that correct?
Yes, involuntary separation, yes.
And who made that decision?
That also would have been the first assistant.
Did you support the decision to terminate his employment with the office?
Based on all the facts presented to me and the applicable state and federal law, yes, there was a variety of reasons. There was a lack of confidence in his...
Objection, Your Honor. Hearsay. The witness just testified based on information he received.
Sustained.
Mr. De La Garza, did you provide any recommendations concerning Mr. Vassar's, the involuntary separation?
Yes, I mean, as a HR director, I have to rely on information that is presented to me.
Okay, and sorry, I didn't mean to talk over you. When you were providing those recommendations, were you advised by management of some issues, some job performance issues that they were experiencing with Mr. Vassar?
Objection. Hearsay. Advised by management. Out of court statement, Your Honor.
Your Honor, if I may, I'm asking about the facts that inform his recommendation. I'm not offering them for the truth of the matter, but rather for just the things that he was aware of at the time he made his recommendation.
You're definitely offering them for the
and
truth.
Why he made that recommendation.
100% offering them for the truth.
I'm going to sustain your objection. Find another way to ask the question.
Thank you, Your Honor. Did agency policy support the decision to terminate Mr. Vassar's employment with the agency?
Yes.
And was it your understanding that Mr. Vassar had violated agency policy by sharing confidential grand jury
Objection,
subpoenas
hearsay.
outside of the agency.
Objection, Your Honor. I need to interrupt. This is knowledge gains through hearsay and leading.
Sustained.
Could you please describe what the violations of agency policy were that supported termination?
Well, just overall, as far as the reasons presented to me
Objection,
for
hearsay.
separating him were, there's a combination of
Objection, Your Honor. Reasons stated to me is an out-of-court statement, hearsay.
Thank you.
Your Honor, again, this goes to the basis for his recommendation. This is not he's not testifying as to the truth of it, but rather the
Bullshit,
information,
you're
his
not.
understanding of the information.
Bullshit, you're not
and
testifying
what
the truth of it.
informed his advice to the agency.
Sustained.
We'll overrule your objection this time.
Oh, bullshit
You
ruling.
can answer the question, Mr. Delacour.
Yes, I mean, I have to rely on the facts presented to me.
Bullshit,
We
you're
have
not offering it
4,000
for the truth of the
employees.
matter asserted.
So with respect to Mr. Vassar, I had to rely on the facts
I see
presented
what
to
you're
me
doing.
on what he
I'm not this dumb.
had done or had not done. And so as far as the overall reasons, there was a variety of reasons. A lack of confidence. There were some
You don't
issues
know that.
about his performance.
This is all based on
some
things
issues
he
about
was
the handling
told.
Of
This is what
grants
he
or
was
mishandling
told.
of
It's
grants.
classic 100% hearsay.
Overall, there was some
Get the manager
insubordinate
in
tone
who observed
and
it
demeanor, and
so we can
overall,
cross-examine it. This is some
there
bullshit
was,
hearsay.
My understanding, there was one last.
The reason I made the
meeting to see
decision
if
was
there
'cause all the
any
things, which I'm
reasonable
definitely not offering for the
expectation
truth of the matter,
that
sir. You
Mr.
100% are.
Vassar could or wanted to work with or for his new boss.
Objection, Your
Webster.
Honor. I apologize for interrupting. Can we keep this question and answer? My objection is narrative.
Thank you. That's a very valid objection, too.
Sustained.
Mr. De La Garza, let me ask you about that meeting. You mentioned that there was one last meeting before there was a decision made to separate Mr. Vassar from his employment at the office. Were you present at that meeting?
No.
Were you later requested to provide counsel as a result of what had happened in that meeting?
Yes,
And sorry, I'm going to stop you right there just because I want to make sure that we're keeping
I
this question and
apologize.
answer. But I appreciate your testimony. When you were asked for advice, did you ultimately recommend separation?
Yes.
And do you agree with that decision today?
Yes.
Let's talk about Mr. Maxwell. Was he the director for law enforcement?
Yes.
And was his employment also terminated from the Office of Attorney General?
He was involuntarily separated on, yes.
You don't want to use the word fired,
And
huh?
who made that decision?
First Assistant Brian
Did-
Webster.
Did you advise Mr. Webster with respect to that decision to terminate Mr. Maxwell's
Sounds like
employment
Mr.
from the
Webster should be
agency?
testifying to me.
I recommended that it could be done, that it was reasonable based on the facts presented to me.
And did you
Based on the
personally
facts presented to
have,
me.
prior
Here
experience with Mr.
to
Maxwell
the say.
and some violations of agency policy in the past?
Yes.
And how would you recommend, or excuse me, how would you describe your
Who
experience
for
working
fire
with
says,
Mr. Maxwell?
how's the HR director supposed to explain their termination
I mean,
decisions?
I admire
He's
all
not.
he's done, but with respect
guy who made the
to,
termination decision
HR
is the one who should
issues,
explain the termination
in
decision.
HR, certainly, it was a developing pattern.
He has no knowledge.
Of not
He's a
going
he's a
to
bad witness.
HR for guidance on some very sensitive HR matters.
And did the failure to go to HR for guidance on very sensitive matters, did that ultimately expose the agency to liability?
It could have.
And about how many instances?
Well, there was one case with a Hispanic peace officer, a female who had been subject to sexual harassment.
Objection, Your Honor.
relevance.
This is knowledge gains through hearsay. Presumably, he did an interview with this woman who will not come in to testify. All of the information he gathered and he's relaying to us is hearsay.
Your Honor, I'll move on.
Sustained. Continue.
I'd like to offer what's going to be marked as AG Exhibit 1055. I understand counsel does not have an objection to this either.
No objection, Your Honor.
Admit 1055?
The
And,
only
Your Honor,
reason
may I,
this guy
approach the
should be to
witness
the
with a hard copy?
stand,
Thank
his
you.
only value should be we have policies in place that don't allow people to be insubordinate. That is the standard policy of the
Mr.
office.
Arroyo, could you please
That
pull
is
up
the
AG
full
Exhibit
extent of his
1055?
testimony. These go to everybody. Everyone has to do it. That's all he has knowledge of. Everything else is some hearsay bullshit. Because he
Mr.
isn't the one that
Delagarza,
made the termination
you
decision.
recognize AG Exhibit 1055
He isn't the one that observed it.
as an email that you drafted to Brent Webster and Aaron Wrights.
Yes.
And does this memo provide your legal advice regarding these?
Right
the
about
continued
now, as a
employment of
judge,
these,
I'd be
staff
thinking about
members?
excusing the witness,
Yes.
striking all of his testimony,
could you-
and be like, how about bring a
What
witness
prompted this
that
email?
actually has some value? How about that?
Mr. Maxwell and Mr. Penley, Mr. Maxwell and Mr. Penley had been on investigative leave, and they wanted to have a meeting to see if there was any reasonable expectation that they could work with or for Brent Webster.
And I'm sorry, Mr. Delagarza, just for the record and for clarification, when you say they wanted to have a meeting, who is they?
Well, primarily the first assistant, Brent Webster.
Thank you, and I'm sorry to interrupt. Please
Is
go
the
on.
reason they didn't think they could work with the guy because he was a
there
dirty,
was
dirty
this
whistleblower?
Kind of a
Is that the reason that
sort
they
of a
thought
last
maybe he
ditch,
might be a
let's
clash
see
for the
if there's
culture?
any reasonable expectation that they could work with or for Brent Webster, the new first assistant, and whether there was any reasonable expectation that they could continue as high-level policymakers with Attorney General Ken Paxton.
And so is this email your suggestions of things to ask in those meetings?
Yes.
Why did you pick these particular questions, like, do you trust me? Do you trust the Attorney General? Are you committed to the vision? Why did those questions make it into this memo?
Well, based on the case law, Elrod.
You fired him because he said he didn't trust the Attorney General? Is that really what you want to go with?
What
Are
you
you
focus
sure?
on, the loyalty,
Holy
trust.
shit.
Can the elected official, trust the people that he's or she is chosen to?
Yeah, so you didn't trust
support
them because they were
their vision,
whistleblowers.
their goals.
And why would that be important to the agency?
Do you trust the
Well, it's
Attorney
definitely a
General?
question about
Well, seeing as I'm a
efficiency.
whistleblower who
I mean,
went to the
you-
FBI
you-
because I believe that
you
he's a
want
criminal.
the-
You know, I have some doubts in my
everything to
mind.
move along.
Okay, we're going to
If
fire
his,
you because
if his
you don't have the trust of the Attorney
deputies
General.
aren't, if they're not seeing eye to eye, it's going to break down, and then it eventually starts trickling down, and we start losing, efficiency, and there could be worse problems.
I would be so mad as a court
Mr.
judge
Arroyo,
right now.
could you please pull up
I'd be so mad
House
as a
Manager's
judge.
Exhibit 383? And, Your Honor, this is
I
already in
would have
evidence.
kicked this witness out of my courtroom long ago.
May I approach the witness with a hard copy? Thank you.
I would have kicked this witness out of my court long ago. Dude, why is he here? He has nothing of value to offer us.
Mr. Delagarza, do you recognize this email that was sent by Greg
Get
Simpson,
out
your
of my
former boss,
courtroom.
to
Get
Brent
out.
Webster copying you related to the CID division?
Yes.
And I don't want to go through this whole thing, but I just want to ask you, on the second page, could you please read aloud the last two sentences on the last page of this document?
It reads, overall, HRD has had difficulty getting CID to work with us on matters that are appropriately and exclusively within HRD's authority. Maxwell's actions have exposed the agency to potential liability.
And what does HRD and CID, what does that mean?
HRD would be the Human Resources Division, and CID would be the Criminal Investigations Division.
And the Criminal Investigations Division, that was the division that Mr. Maxwell was chief of, correct?
Yes, that's one.
I'd probably be sua sponte, just being saying sustained.
And so does this
I wouldn't even
email,
wait for the objection.
Identify a number
At this
of
point, I'd
issues
just be
with
sustained.
Mr. Maxwell's management
There was no
of his
objection.
division?
There was in my head.
Yes, Mr. Simpson explained that there were some challenges that HR had faced.
Did you agree with the decision to terminate Mr. Maxwell's employment with the agency?
Yes, based on the facts presented to me and the applicable law.
Based on the facts presented to me,
And,
objection, all the
Okay, you can
hearsay.
set that aside. Thank you.
All the hearsay. He lacks personal knowledge.
Do you
He's
agree with
not
that
a
decision
witness.
today, Mr. De La
This is
Garza?
some bullshit.
I do.
And who made that decision?
That would also have been the first assistant, Brent Webster.
I'd like to talk to you about
Where's
Mr.
Brent
Penley.
Webster?
Do you recall that he was the Deputy Attorney General?
Since he
for
seems to be
Criminal
the guy
Justice?
making the decision and has all
And
these
he was also
problems, where is
involuntarily
he?
Separated?
Yes.
Call
Was he
Brent
offered
Webster to the
option
stand.
resign?
Yes, he was.
That's the guy you need.
And
Call
2
that guy.
months Before Mr.
Who the hell's this
Penley was let
asshole?
go, did he meet with Brent Webster?
Yes.
And did he have the meeting that you suggested or that you mentioned earlier about whether there could be a reasonable expectation that Mr. Penley could work effectively with the new first assistant?
Yes, that meeting took place.
And what was your understanding about the prospect of Mr. Penley being able to effectively work with Mr. Webster following that meeting?
My understanding from that meeting, it was
My
that there
understanding
was no
from the
reasonable
meeting, objection,
expectation that
hearsay.
Mr. Penley wanted to
You're
work,
talking about what Mr.
with
Penley
before
wanted.
his new boss,
Hearsay.
First Assistant Brent Webster, that he could in the future, and that he could serve as a high-level policymaker for Attorney General Ken Paxton.
Did agency policy support Mr. Penley's involuntary separation?
Yes.
How so?
Well, just based on the lack of confidence, there was
lack of
there was some evidence of
Would that lack of confidence be based on
questionable decision making.
anything in particular that may have recently happened?
Just the
Would there be any
breakdown
particular
in the working
basis that he
relationship.
just
There
happened
may
to not have
also been,
confidence in him?
from what I recall, some insubordinate tone or demeanor towards Brent Webster. And so just overall, based on the applicable state and federal law and the facts presented to me, it seemed reasonable, and the policy supported that.
Was it also your understanding at the time that Mr. Penley had omitted some material information in a court filing?
Yes, that had been also presented to me
Objection,
as far
hearsay.
as some
Also, now he's wheezing.
wrongdoing, whether it was misconduct.
I apologize for interrupting. This had been presented to me as hearsay, out-of-court statement. We object to hearsay.
Your
Stand
Honor,
for
this
love
is
of
the
God.
same ruling that you made earlier to overrule the objection. This is
Yeah, the earlier
facts that
ruling
were
was
presented
wrong.
to him that informed
Now would be
his
a great
advice
time
to
to
the
correct that,
agency,
Judge.
and that was subsequently conveyed to Mr. Webster, who determined what.
You know, that
the
earlier
decisions
ruling
would
I
be
made
going
about the
forward.
hearsay was some
If I-
bullshit. Oh, no, but I'm going to overrule it and keep going.
continue.
Okay, that's fine.
What was the question
That's
again?
equally good. Just
Yes,
overrule the
question
objection.
was
That's
whether
fine.
it was, you know what, I think you answered it. Thank you, Mr. De La
thank you.
Garza. I will ask you a follow-up question. You said it was your understanding that facts had been presented to you that Mr. Penley had omitted material information from a court filing. Is that right?
Yes, that was the facts presented to me.
And do you know whether that constitutes a violation of the agency's policy on handling confidential and privileged information?
Yes, we have a specific policy on that.
And did you agree with Mr. Webster's decision to terminate Mr. Penley's employment?
Yes, based on the law and the facts presented to me, it was a reasonable decision.
And sitting here today, do you stand by that support, that
I'm
recommendation?
back to my earlier question of how deep is Ken Paxton's hand up your ass, sir? Can I ask that question on cross, or is that too much?
Mr. Arroyo, could you please pull up AG Exhibit 120? And Your Honor, this is not in evidence, so I'm going to offer it now. I understand that counsel does not have an objection.
No objection.
Admit AG 120 into evidence.
And, Your Honor, may I also approach the witness with a hard copy?
Yes, you may.
Thank you.
This is so all the hearsay. This witness is nothing but a massive hearsay. This is
Mr.
hearsay. The
do you
witness.
recognize this email?
Yes.
If hearsay
And
were
does
an
this email,
embodied, it would be
reflect
this
some of
guy.
the legal advice that you provided to the agency, including to Mr. Webster, about the application of the Whistleblower Act?
Yes, I provided some what I considered privileged and confidential advice regarding the petition
sure
that
you
had been
did.
filed.
Understood. Mr. De La Garza, looking at the first paragraph of this email, you write, "Here is my list of why Vassar, Maxwell, Penley, Brickman should be considered high-level policymakers who are exempt from whistleblower protection." Do you see that?
Bullshit.
And I want to ask you about that term, high-level policymakers. What does that, why was that important?
That is the term used in sort of political patronage case law.
So you're back to they weren't subject to whistleblower
That elected
protection.
officials can
That's your
appoint.
brilliant analysis.
They have to be high-level policymakers for them to be appointed.
I'm sorry, I just want to, they have to be high-level policymakers
Wow.
to be appointed. Is that what you
Yes.
said? Thank
Wow.
you. And all of the former staffers who made reports to law enforcement, in your view, fell under the category of high-level policymakers.
Objection leading.
I mean, I've only
just
read
clarifying
I've only read the
back to
whistleblower
restate.
statute like
Just
3 or 4
restate.
times on stream
Mr.
at this
De La
point.
Garza,
I
is it
really don't
your
remember the section
opinion
about high-level
that the former
policymakers.
staffers who made reports to law enforcement were all high-level policymakers?
They were high-level.
Maybe the cross will be like,
And,
is this a copy of the
Could you
whistleblower
just
statute?
summarize for the jury
Can you tell me where it
some of the
says
points
high-level
that were important
high-level
to you
policymaker?
here that led you to your conclusion that they constitute high-level policymakers that are exempt from the Whistleblower Act?
Well, based on the list that I have here, and it was supported by case law, they required more than simple ministerial competence. They created or implemented, agency goals, policy. They controlled or exercised a role in the decision-making process as to the goals and general operating procedures of the agency. They ensured that policies which the electorate had sanctioned by electing the Attorney General were effectively implemented. They all had access to confidential documents or other materials that embody policymaking deliberations and determinations. Party affiliation was an appropriate requirement. They served as
Sorry, Mr. De La Garza, if I could, I just want to stop you there. At the bullet point about party affiliation. You write here that party affiliation was an appropriate requirement for effective performance of the public office involved. Is party affiliation something that the agency would look for in the employees who apply for competitive jobs in regular postings?
No.
Mr. De La Garza, do you stand by this advice in AG Exhibit 120 today?
I do.
Thank you. You can set that aside.
I'm sure he'll inform us on cross where it says in the whistleblower
Mr. De La
statute
Garza,
that it doesn't
did the
apply to
Office of
high-level
Attorney General
policymakers.
have legitimate, non-retaliatory reasons for terminating these staffers' employment?
In my opinion, yes.
Bullshit.
And under the Texas Whistleblower Act, can the Office of Attorney General or any state agency terminate a whistleblower based on information or evidence that is not related to their whistleblower report?
They
Yes.
can.
And do you agree that that for the agency to be effective, that high-level policymakers need to be able to collaborate effectively with the first assistant and with the attorney general?
Yes.
Did you believe that there was any reasonable possibility that any of these former staffers could do that?
Well, Darren McCarty resigned. There could have been Ryan Bangert. So, I would say that there was possibly with them, but
For the ones that resigned, but for the ones that were terminated,
It
for
just
the
so
ones that were
happened the
terminated,
ones
was
that
there a reasonable
it just so
expectation
happened the ones that
they could
resigned.
work with the
There was
first- the new
every
first
possibility
assistant and
we
with the
could have
Attorney
worked with
General.
them.
yes.
But the ones that
For
were
the ones that
fired,
were
no possibility
involuntarily
there.
Separated.
What a weird
no, in my opinion,
coincidence.
there was no reasonable expectation.
What a strange coincidence. All the ones who resigned,
Did
man,
Ken
we really wish
Paxton
they had
ever
stayed on.
indicate
We had every hope of being able
expressly
to work
or
with them. They were
implicitly
great employees.
that these former
we don't know why they
staffers
left.
needed to be fired
But the
because
ones that
they
were
made a
fired,
report to law
man,
enforcement?
Not
They
to
were
my knowledge.
incorrigible.
Do you have any knowledge that Brent Webster ever indicated, expressly or implicitly, that these former staffers needed to be fired because they made a report to law enforcement?
Not to my knowledge.
Did anyone at the Office of Attorney General determine what your recommendations would be with respect to the legal advice you provided for these former staffers who were involuntarily terminated?
Not to my knowledge.
This is some bullshit.
Was your analysis of whether the former staffers had violated agency policy, was your analysis an independent analysis?
Yes.
No, not really, because you
I mean, at
completely
times I
depended on what
consulted
everyone
with
else told
the
you.
other
That's this
lawyer,
very
my
strange view of
boss,
what independent
before
means.
he
You
left.
made absolutely no effort to determine the facts for
Mr.
yourself by your
Arroyo,
own
could you
testimony.
please pull up Article of Impeachment 6?
So it was independent in so much as I was completely relying on what other people told me.
And could you turn to the next paragraph of Article 6, please, Mr. Arroyo? Mr. De La Garza, Article 6 accuses the Attorney General of terminating the employees without good cause
Isn't it true the
or
Attorney
due
General is not guilty of
process,
Article 6?
and in retaliation for reporting his illegal acts and improper conduct.
Is she going to
Do you
answer
see
that? Ask that question? Is
I
she
do.
going to ask, isn't it true he's
Is
not
good
guilty?
cause required to terminate an employee in Texas?
No, it's not. But at the Attorney General's office, we ensure that there are good reasons and that it's fair.
And did good reasons and fair reasons exist for each of the former staffers that were involuntarily terminated?
In my opinion, yes.
Is due process required to terminate an employee in Texas?
No, there's no property right to our jobs since we're at will. So due process, there's no constitutional right, and but we ensure that it's fair.
So, okay, thank you.
So we
And
don't have to,
were
but we
any
do.
of the former executive administration staffers
We don't have to, but
terminated
we
in
do.
retaliation for making a report to law enforcement?
In my opinion, no.
Bullshit.
Thank you, Mr. De La Garza. I pass the witness, Your Honor.
Bullshit.
Thank you.
Bullshit. Bullshit.
Please state your name for the record.
Yes, Your Honor. Yes, Your Honor. Daniel Duco?
Daniel, you better bring it. I swear to God. You better bust this guy like a piñata, or I'm going to be really mad.
Hi, Mr. De La Garza. How are you?
Fine, thank you. How are
Mr.
you?
De La Garza, you testified a moment ago that you are familiar with the Texas Whistleblower Act, correct?
Yes, I did.
And you understand that the Texas Whistleblower Act affords protection to people that go to law enforcement so they can go to law enforcement without retribution, right?
Yes.
And as part of the Texas Whistleblower Act, that protection only extends to people who still have their job.
Yes, they are, yes.
Right. So what I mean is, if you report someone to law enforcement and they still have their job and then they're retaliated against, they are protected by whistleblower, correct?
If they comply with the retaliatory, the requirements in the Texas Whistleblower Act, yes.
But if they get fired before they go to law enforcement, they're not afforded the protection of the Whistleblower Act, correct?
Right, it has to be, right.
Right. So before you go to law enforcement, you don't want to tell your boss, I'm going to law enforcement.
Objection, speculation.
He
Sustained.
Under the Whistleblower Act, if you tell your boss you're going to law enforcement, you get terminated, then you go to law enforcement, you're not entitled to the whistleblower protection, correct?
Objection, speculation. It's the same question, Your Honor.
Just said he knew this.
You can answer if you know.
All right, could you just repeat the question, please?
Sure. Under the whistleblower statute that you said you're familiar with, if you tell your boss, I'm about to go to law enforcement, then before you go to law enforcement, you get fired, then you go to law enforcement, you're not entitled to the protections of the whistleblower statute, are you?
I guess you could make the argument in court. I'm not sure how successful you'd be.
But you agree with my statement, correct?
Probably wouldn't be the best way to do it.
So if someone were to stand up here over and over,
Witness needs to speak up when you speak.
Oh, excuse me.
if someone were to stand up here over and over and say, why didn't you just call your boss? Before you went to law enforcement, why didn't you just call your boss? Under the Whistleblower Act, that wouldn't be a good idea, would it?
I mean, if your plan was to file a lawsuit, then yes, you shouldn't do that.
You should not go to your boss first.
If you were planning to file a lawsuit, I mean, it depends on the situation.
I'm not talking about a lawsuit. I'm talking about whistleblower protection. It would not be a good idea to call your boss first, right?
Objection, asked and answered.
Overruled.
Right?
You're asking me to speculate. I'm not sure what a plaintiff should or shouldn't do.
You don't want to answer that, do you?
I'm not here to, speculate as to what a potential plaintiff under the Whistleblower Act should do or could do.
Just so we're clear, you're not here now. A moment ago, you were okay with it, right?
Objection, Your Honor. It's argumentative.
Sustained.
All right, let's put up AG 120, please.
If you don't put up the statute and ask him where it says something about high-level political people, I'm going to be a little mad.
Can you see AG 120?
Yes.
This is a document that you created, an email, right?
Yes.
And in this email, it says, here are my list of why Vassar, Maxwell, Penley, Brickman should be considered high-level policymakers who are exempt from whistleblower protection, correct?
Yes.
This is your analysis.
This was a privileged and confidential document that we are brainstorming.
I appreciate that, but I think I wrote down your words, and what you said was, this is my analysis. You still stand by that?
Sure.
And you said, I stand by that today.
Yes.
And you said to the senators here, this is the correct analysis, right?
At the time, I believed it was the correct analysis. So
This argument, this exact argument that's in this document right here, was made in the court, right?
I'm not sure. I wasn't involved in that.
You're not familiar with the Court of Appeals case, Office of the Attorney General versus Blake Brickman, Mark Penley, David Maxwell, and Ryan Vassar? You're not familiar with that?
I'm familiar, but I wasn't involved. I didn't work on that appeal.
Are you familiar with the decision that came out in that appeal?
I would have to read it, and
You don't remember?
to be honest, I'm not sure if I carefully, that was not something that I needed to read.
Well, if
Really?
you had read it, you would know that the Court of Appeals said all of your analysis in AG 120 was wrong. right?
Objection, argumentative.
He knows,
Overruled.
right?
It happens as lawyers, we make arguments and courts don't agree with them. And so, there's always going to be a winning side and a losing side. And at the time, I was just coming up with potential arguments. That's what, we do.
Right, so when the senators are deciding whether or not this is a valid argument, they can disregard it because the Court of Appeals already decided it was not.
Objection, this misstates testimony and is going outside of direct. This also is talking about a document that is not in evidence, and there's been no testimony before this witness about.
Overruled.
Right?
I defer to the Senate to do the right thing.
You spent a lot of time telling us about how people were involuntarily separated. That means fired, right?
Yeah, we just like to use involuntary separation.
Okay, I just want to make sure we're on the same
Yes.
page. That means fired.
It does.
You also spent a lot of time using the phrase based on facts presented to me, right?
Yes,
And those facts were presented to you by Brett Webster.
for the most part, yes.
Doesn't it seem like you had a Brett Webster problem?
Well, he was the new first assistant, and these employees were reporting to him.
I mean, you've heard the term garbage in, garbage out, right?
I've heard the expression.
So if Brett Webster is giving you information that's not true, then your analysis is wrong, correct?
I have to rely on the information given to me.
I appreciate that. My question is a little bit different. If Brett Webster's not telling you accurate information, then all the analysis you gave on direct examination is all incorrect.
Objection, speculation.
He knows,
Overruled.
correct?
I have to rely on the facts presented to
That
me.
wasn't the
so
question. We can do it a third time.
Is my
Yeah.
question difficult?
It's, you're saying that if he presented false, if he presented false information to me, and I'm using that false, yes, it could affect my analysis.
There you go. There's the right answer. Thank you.
Well, let's talk about the real reason why these people got fired. Stacey, can you put the timeline up, please?
Yeah.
I'm going to use this for demonstrative purposes, so.
Your Honor, I'm going to object. I've never seen whatever this is before. Counsel and I discussed exhibits during the break. This was not provided to me, so I would request that we get a copy of whatever this is to quickly review.
Not an exhibit, Your Honor. Simply demonstrative purposes, not going back based on dates that this witness provided on direct examination. If the dates are wrong, counsel can correct me.
Well, Your Honor, I mean, we might have an objection to whatever he's going to put on this timeline. I don't know what it is, and I don't have an opportunity to verify it, and it's being published to this jury as if it's fact. So I'm going to object to displaying this to the jury.
Your Honor, they're making evidentiary arguments. I'm not offering this into evidence. It's purely demonstrative.
Your Honor, this...
Hold on. Don't talk over each other. I think you can provide the counsel with what you're about to show. Yes.
Thank you.
Dude. You need Brett Webster on the stand. You need him to be able to justify all this. This guy is hearsay the witness. This guy doesn't know anything.
Your Honor, I might have objections as this goes along because I don't think there's any foundation that he's laid yet, at least, to ask to publish these as something that's within this witness's personal knowledge. But subject to that, I appreciate counsel providing this copy, and we can move along.
Move along.
Mr. De La Garza, on September 30th, and just before we get started, I want to point out this timeline.
Mr. De La Garza, how long have you known that you're a tool?
Stay at the microphone.
Yes. I want to point out, Mr. De La Garza, that this timeline
know what a
is roughly
sycophant is
a
by any
month and a
chance?
half, less than a month and a half. Do you see that?
Yes.
And as you are familiar with the whistleblower statute, as you testified on direct examination, I'm sure you're familiar with 554.004, right?
Could you remind me?
Sure. It says, in an adverse action, if within 90 days of reporting to law enforcement, there's a presumption of retaliatory conduct.
There is a presumption that can be rebutted.
And so the law says, if within 90 days of reporting something to law enforcement, you're terminated or have an adverse action, we are to presume that was retaliatory, right?
There's a presumption.
So, September 30th, whistleblowers go to the FBI, right?
I'm not sure. I have no personal knowledge of what they did.
The head of HR, you don't know?
That's what I heard. That's what they presented to
Well, everything
my
else you
boss, a
did is
letter saying
hearsay,
that
so
they
might
had
as
gone
well
there.
add that to
Let's
the list.
start over. You're the head of HR, right?
Now, yes.
You know that they went to FBI on September 30th, right?
I have received information that they did. I have no reason to disbelieve that.
You also know on October 1st, the whistleblowers notified HR and the AG Paxton of the FBI report, correct?
Yes, I believe it was the first.
The next day, Mark Penley and David Maxwell were placed on administrative leave.
That's correct.
On October 13th,
Yeah.
David Maxwell made his formal complaint against Ken Paxton.
I'm not aware of exactly when he did formal
The
complaints.
day
go to
after he
formal
tells the
complaint
AG
officer, so
they're put on leave.
If you say it was the 13th, but
You
Dude.
spent a lot of time telling us about David Maxwell. You reviewed all the
Dude.
file. You're telling
Good
me you don't
fucking
know when
luck
David Maxwell made
justifying
his formal
that.
complaint?
Good fucking luck. The day after they
I
go to
don't
the
have
FBI, they're
personal
placed on
knowledge of
administrative
that
leave.
because formal
Good
complaints go
luck
to the
justifying
formal
that as not
complaint
being
officer. They
based
don't
on
go to
being a
HR.
whistleblower.
Well, we can
Holy
assume by the
shit.
fact that your lawyer hasn't stood up and objected that that's the day he made his formal complaint, okay?
No reason to disbelieve that.
October 15th, Brickman, Vassar, Bangert, McCartley, and Penley all file formal complaints. You know that as well, right?
I understood that they all filed formal complaints.
October 20th, so 20 days after going to the FBI, 19 days after the whistleblowers notify of the fact that they went to the FBI, Blake Brickman was fired, right?
Yes.
Lacey Mace was fired.
Yes.
November 2nd, a month after going to the FBI, David Maxwell was fired.
Yes.
November 2nd, a month after going to the FBI, Mark Penley was fired.
Yes.
November 17th, 6 weeks after going to the FBI, Ryan Vassar is fired.
Yes.
Have you ever heard of the expression, there's no coincidences in Austin?
Yeah!
Pass the witness.
Redirect.
Just briefly, Your Honor. Mr. De La Garza, did agency policy support the termination of Lacey Mace?
Bullshit.
Yes.
And did you recommend that termination?
I did.
Do you
This
stand
is
by that
such
recommendation
shit.
today?
I do.
This is such absolute shit.
No further questions, Your Honor.
Sure. Oh, yeah.
No need for
Oh,
it.
yeah, it's definitely our policies that did
Excuse the
it.
witness.
Yes, Your Honor.
Yes. You may step down. Thank you. Little housekeeping before the next witness. I said that after the break, I would admit 702 into evidence. We did
Within
not do
30
that,
days,
so
they're all
702
disciplined, fired, put on
admitted
leave.
into evidence, Mr. Dowell.
Sure,
I
it
think
was
that's
for
correct.
cause.
So if both parties would like to come to the bench for a moment.
And also, I still object to this guy on every possible level as being hearsay the witness. I object to this guy as being hearsay the witness. This guy knows nothing. He isn't the guy that made the decision to fire. He's simply like, did other people tell you things? Yeah. And based on those things, you think it was a good decision? Yeah, sure. Yeah, sounds good to me. Yeah. I think he helped the prosecution's case by the end of it, to be honest. This guy's so incredible. Fucking bullshit. I would have thrown this guy out of my courtroom. I'll tell you what, man. Don't bring this bullshit in my house. This guy has nothing of value. He didn't hear anything. He didn't see anything. He's just a monkey. People tell him things and he bangs his drum and wow, it's all good. Wow. And we have a manual that says people can't be insubordinate and we didn't like their tone. It was their tone. We lost confidence in them. Would it have anything to do with the fact that they were whistleblowers? Would that be perhaps the reason you lost confidence in them? Would that be the reason? You just magically happen to lose confidence. I just don't like this guy anymore. I don't think he's really good to work with me. I don't really have confidence anymore. Would it have anything to do with the fact he's a whistleblower? Isn't it true the Court of Appeals owned your ass on your
Court will
completely
come to
stupid
order.
memo? Well, you know, I just am a lawyer making arguments for my client.
Members of the jury, there was a motion filed yesterday by the House to amend the rules to collapse a vote into one vote. That motion has been withdrawn.
Yeah, that motion was stupid.
Will the defense call their next
I don't know why
witness?
they filed it in the first place. That was a stupid motion to collapse it. It's like, why at this point? It didn't make any sense to bring it.
Defense calls Grant Dorfman to the witness stand.
All right, Grant.
Please bring in Grant Dorfman.
Who the fuck are you, and why are you talking to us? And why isn't the other guy here? Why isn't the first AG here? He's the one who apparently observed all the things and knows all the things, and he can comment about their tone and behavior and what they said and all the things, right? Here's what they did. Here's what they said. Here's how they acted. This is why I made the decision. You know, maybe put yourself subject to cross. You know, where's that guy? Are they going to call the first AG? I'm guessing not. We're going to call Grant Dorfman. Brant is going to answer our questions. Grant? Is it Grant instead of Brant?
Mr. Dorfman, if you'd raise your right hand. I do solemnly swear or affirm that the evidence I give upon
Guru
this
Fuhar,
hearing
you
by the
are
Senate of
on
Texas of the
crack.
impeachment charges against Warren
You are
Ken
on
Paxton Jr.
crack.
shall be the truth, the whole truth, nothing but the truth, so help me God.
And even if that were
Please have a
true, we
seat.
don't have any evidence of it. All we have is some bullshit hearsay. You are on crack.
Thank you.
Your witness.
May I proceed? And it's Anthony Osso, O-S-S-O, on behalf of Attorney General Paxton. Sir, would you please state and spell your name for the record?
It's Grant Dorfman, G-R-A-N-T. Dorfman is D-O-R, F as in Frank, M-A-N.
Okay, and I understand you're a judge, but just to keep the record clear, I'm going to call you Mr. Dorfman if that's all right.
I appreciate that.
Okay. Mr. Dorfman, could you please tell these senators how you're currently employed?
I'm the Deputy First Assistant at the Office of the Attorney General.
Okay.
Your deputy
I'm going to
first
ask that you
assistant.
lean into that mic and speak loud and clear so that everybody in the courtroom can hear you. Now, before we talk about your role as the Deputy First Assistant, I want to talk to you a little bit about your background and who you are. Can you tell us where you're from?
Grew up in Dallas, Texas.
Okay. And where did you end up going to school?
Brown University in Providence, Rhode Island.
Okay. And then, was that for undergraduate?
Sorry?
Undergraduate?
That was my
Grant Gooch,
undergraduate.
you are so
Did
full
you
of
go on to
shit.
do law school?
If you can't
I
see
did.
retaliation
Can you
at
tell
this
us where you
point,
went?
you are
Yale Law School.
blind.
And what did
You
you
are
do after you
blind.
completed your time at Yale?
I accepted a clerkship with a federal judge in Houston, Texas, brought me back to Texas after 10 years on the East Coast. I also took 2 years out before law school, got a graduate degree there.
Either that or
not
Ken
in
Paxton
England as well.
has your hand up his ass, up your
and then
ass.
had a
Are you by
one-year
any
clerkship
chance
opportunity in
an
Houston.
employee of the AG's
Thought I was
office?
going back to D.C. to join the Department of
Is that
Justice.
why
for
the Attorney
second
General
term
has
of
his
the
hand
George
so
Herbert
far up your
Walker Bush
ass?
administration. That never materialized, so I ended up
so what-
blessedly staying in Houston.
Okay, so after that didn't work out, what did you end up doing next?
I went to work for a commercial litigation boutique and continued in that line. Went to a second firm where I made partner in, I think, 1999.
Okay, which firm was that?
Ogden, Gibson, White, and Brooks, and the first firm was Sussman Godfrey.
Okay, and while you were working as a partner, can you describe to us kind of what type of law you were practicing?
Commercial litigation, generally, that's a big area, but civil trial work
Okay.
And appeals, and a lot of energy work, a lot of employment cases, and just the
If retaliation is justified, why should you care?
things that Houston trial practices made
Because
out
it's
of.
the law.
Understandable. What did you do after
That's
you spent
why.
your time working as a partner at the law firm?
Well,
Because it's the law.
had a desire for government
That's why
service.
you
I'd
should
never
care.
really set it out to be a partner at a law firm and continue that for the last 30 or 40 years of my career. So I'd applied to the Department of Justice when the George W. Bush administration came around, went up to interview for 2 vacancies in deputy AGs in the civil division. I ended up withdrawing within 1 week of the interview because my daughter was on the autism spectrum disorder. She was then 4 or 5 years old. And it turns out, to my surprise, but after exhaustive research, The school she was in Houston did not have any counterpart, any comparable service
It all
in
can be
either the
stupid.
Washington or Baltimore metro area. So I had to withdraw from consideration for that.
And
That
I
lit a
don't know why
fire
you're on
under
a
me,
legal analysis channel.
reminding me that's kind of what drew me to the law in the first place.
I don't care about
And
the law. I'm not sure what
Let me
value I
stop you
can
real quick. So that's
provide
back to
here.
Houston, right?
I'm still in Houston.
Okay.
Never left. But then I put in for an application to Governor Perry's office for 2 district court vacancies in 2002.
Okay. And can you tell us what happened with that application?
It was successful.
Okay.
I was appointed to
Has anything
129th
happened
District Court in
interesting
Harris
happened
County.
today?
It's a civil
Yeah, we heard from the
district
head of HR,
in May of
who
2002.
basically
And can
is
you
a
tell us
worthless
what happened
prick
after
and,
that term and farther on in your career?
is
I'm
Mr.
sorry, I didn't catch
Hearsay.
that last part.
After you
And
served
we're
as a
having
judge, a civil court judge in Houston, what did you do next in your career?
Well, involuntarily, the voters decided in 2008 that they liked President Obama better than the rest of the ticket. I went in-house with Neighbors Drilling as an
got kicked
independent
out of
oil and gas
office, though.
contractor, an oil and gas contractor, I should say, with worldwide operations based out of Houston with about 25,000 employees and managed their civil, all their litigation.
Well, no pants,
And
baby.
then
At that point,
at
I
any
still
point
don't know
did you
what
serve
value I
another
can
term
provide you.
as a
If you're going to
judge,
ignore the law, then
in Houston?
I don't know what value I can
Remarried in
provide you.
2013, wanted to do something different, and reapplied to Governor Perry for a district court bench, and was appointed in
And I don't really
November
think that you think that the law's done.
2013
I
to the
think
334th
that you
District
think
Court,
that
also
you
in
want
Harris
to
County,
protect
same
Ken
kind of court I
Paxton.
presided over before.
I don't think you think the
And
law's
so,
dumb.
in total,
I
about
think
how
if
long
Ken
did you
Paxton
serve
was
as a judge?
Democrat, you'd have no problem.
I think
holding
altogether
a
10
whistleblower
years,
law
not
against
including visiting judge service afterwards.
I think your special pleadings.
And then
I don't believe
at
your
some
problem
point,
is the law. I don't
you
believe
become
you.
deputy first assistant at the Attorney General's office. Can you talk to us about what took you from Houston to Austin for that job?
Yeah, not to dwell on bad news, but in 2016, I, along with most of my Republican colleagues on the bench in Harris County, lost. And I went back in private practice for a couple years. My father passed in that time frame, and I stepped into a family business that needed more care than I could give it as a full-time litigator. So I juggled that with having left the law firm, being a mediator, an arbitrator, available to parties to resolve their disputes, and also a visiting
Whistleblowing was the
judge
last
when,
straw.
the
Well, then
administrative
he fired
presiding
him for
judge
being
in Houston
whistleblowers.
appointed me to
So
service in
they're
that
he's
capacity.
guilty.
So what brings you to the Attorney General's office then? How do you go about applying for that job?
Well, it came sort of out of the blue. I had a call from my friend Austin Kinghorn, who I'd known for several years as a law clerk to
You guys are
one of
fun.
the justices on the Supreme Court, and before that on the Court of Appeals. And he asked if I knew anyone who might be interested in working for the Attorney General. And I said, yeah, me.
Okay. I want to talk to you about that. It's no surprise we're here because there have been a lot of allegations made against Attorney General Paxton. You're aware of this, I assume?
Sure.
So when you get that call from Austin Kinghorn, you're interested in the job. Were you aware of all these allegations at the time?
Yes.
Okay. And can you talk to us a little bit about how you became aware of what was going on?
News reports, as
Okay.
probably most others did.
Was that concerning for you?
Yes, it was.
Can you talk to us a little bit about the concerns that you had after reading the news reports?
Well, I knew the reason they were calling and looking for people was because they had openings, and that was the good news. The bad news was these were serious allegations, serious charges that concerned me. And when I did go up to interview in Austin, and for that reason, probably unlike any other interview I've had, I took special time to press, in this case, First Assistant Brent Webster, on these charges.
What were your main...
Normally the interviewee is the one trying to
Right.
sell him or herself.
You had to cross your T's and dot your I's. Can you talk to us about what your main concerns were coming into the Office of Attorney General?
You might be less interested in this, but I had kids at the time in high school and in junior high, so commuting back and forth to work was a concern. Where to live in Austin, it's not cheap, was a concern as well. So those were, I think you're asking something else.
Well, that's a fair concern, but I am also interested, like legally speaking, you're walking into an office where the Attorney General himself there have been allegations made to the FBI.
Right.
And so what about that was specifically concerning to you in that situation?
Well, as I said, I spoke with Brent Webster when I interviewed, and I was much more pointed and brusque than I would normally be when I'm trying to get the job. And I knew he was a prosecutor, and by all accounts, a good one. So I pulled no punches. I pressed him, asked what I thought were fairly pointed, direct questions as to, okay, this is the allegations I'm seeing in the paper. What's the answer to that?
Kind of like a cross-examination a little bit?
A little bit. And it had an evidentiary quality to it as well, because he very patiently, I thought, given the busy nature of the office and the constraints he was under, took the time with me to walk me through the documents he'd assembled at that point.
Okay. Now, after leaving that conversation, can you talk to us about what your opinion was with regard to taking the job as Deputy First Assistant Attorney General?
Well, I satisfied myself that these charges were, in my opinion then, not well-founded. I knew as part of my job there were a number of interesting things going on in the office, but I also knew as part of that, like the Google ad tech lawsuit was coming. In addition to that, I'd be in charge of defending, I think it was then pending, the Whistleblower Act lawsuit involving these charges. So that was also a concern.
Draw the short straw, huh?
So I assume you take the job because we're here right now.
I did.
All right. And I want to talk to you about, well, when exactly was it that you started as the Deputy First Assistant?
December 3, 2020.
Okay. So that's after everything kind of went down with regard to October and the reports to the FBI, right?
Yes.
You mentioned that you were a part of ultimately the whistleblower suit. Are you aware of reports that were drafted within the office?
Yes.
How many reports were there?
2.
Can you distinguish the 2 different reports that were drafted on behalf of the Office of Attorney General?
Yes, the first one started almost from the time I was there. The first I remember seeing a draft was sometime in January, I think early January, because I was still working from home right after the holiday. I remember that going through edits of 2021. And that was released by our office in August of 2021, publicly on our website.
Okay.
And that detailed the main whistleblower allegations and what our office, after forensically collecting documents, emails, exhaustively compiling everything, was able to put together to address these allegations.
And can you tell us who actually authored or published that report?
The Office of the Attorney General.
Okay. Now, is it safe to call that the internal report?
Yes.
Was there a secondary report that was drafted?
Yes, and if you have a copy, that would help me be clear and precise, but I believe it is on Louis Brisbois' letterhead or in the format of a memo to the Office of the Attorney General.
Objection, Your Honor. Testifying from a document not in evidence, testifying about a document not in evidence, and hearsay.
Thank you.
Sustained.
There's a report in existence, correct?
Same objection, Your Honor.
There are 2 reports.
He's not testifying with regard to what is stated in the document.
Overrule that. Go ahead.
Okay. There is an existence of a Louis Brisbois report, correct?
Yes.
All right, we'll get there. But before we do, I want to be very clear. You started in December of 2020, right?
Yes.
You've looked at both of these reports, the internal report and the Louis Brisbois report, right?
Objection leading, Your Honor.
It's only to lay a foundation, Judge.
I'm going to sustain, just,
Yes, Judge.
ask the questions one at a time.
Certainly. Are you aware of
It's hard for me not to rule, by the way.
Are you aware? It's in their allegation, so I'll talk about it. Are you aware of the 2 reports?
Yes.
Have you read the 2 reports?
Yes.
Now, were you present at the Office of Attorney General during any of the subject matter involved in those reports?
I want to answer no, and I think that's right, but I would have to look at the reports to absolutely confirm. But I think everything that was detailed in both reports predates December of 2020.
Sure. Well, let me be more specific. Are you aware that the Office of Attorney General was involved in an open records request involving Nepal?
Historically, I'm aware. I wasn't there at the time.
Are you aware that they were involved in litigation with the Mitty Foundation?
Yes, again,
And
historically.
Are you aware that there was an informal guidance letter with regard to non-judicial foreclosures?
Yes.
Now, were you present at the office during any of those events?
No.
Were you present at the office during the hiring of Brandon Kamick?
No.
So is it safe to say that you don't have personal knowledge of any of those events that
are you
are
here?
authored in the reports?
Yes.
All right.
Why are you here?
Give me one sec, Judge. I intend to get an exhibit for the witness.
Why are you here? Why are you here? You weren't there during any of the events. Why are you here? Confused Pikachu is confused.
Mr. Dorfin, would you take a second to look at a copy of my exhibit numbers cut off? Attorney General Exhibit 23, and let me know whether you recognize the document.
I have looked at it and I do recognize it.
What is this document?
This is what you're referring to as or referred to as the Lewis Brisbois report, the second report in time that our office released on these matters. Well, I say our office, this was outside counsel sending it to the office.
Okay. And is this a fair and accurate copy of the report issued by Lewis Brisbois on behalf of the Office of Attorney General?
Near as I can tell.
At this time, Judge, I would offer Attorney General Exhibit 23.
Your Honor, there's so much hearsay in there, I don't know where to begin. The document itself is hearsay. Within this document are conversations between people that are out-of-court statements that are hearsay. It relies on documents that are out-of-court statements that are hearsay. It also relies on people talking to other people who talk to other people, which is 3 layers of hearsay. So my objection, Your Honor, is hearsay squared.
In every possible way. Yeah.
Sustained.
Judge, may I respond briefly? My understanding, and Mr. Arroyo, if you would pull up Article 7, please.
Oh my God.
My understanding is that the House Board of Managers allegation in this case is that Ken Paxton and the Office of Attorney General issued a report that basically alleged false and misleading facts. This is a legally operative document in this case.
Your Honor, may I respond?
And the House doesn't want it in evidence? I don't understand how they can argue it's a lie if it's not even in evidence before the jury.
Your Honor, I hope counsel is not trying to mislead this court because this article of impeachment is based on the internal AG report. This report, the Lewis Brisbois report, came out after the article of impeachment. And so I'm sure counsel would like to retract his statement and not mislead this court. Regardless, this is so much levels of hearsay, and this thing up on the screen doesn't get around that.
I don't wish to retract my statement at all. I don't think that the allegation is necessarily clear, and I'm going to continue to argue that this is a legally operative fact.
I would suggest as an officer of the court that he retract it because this report has nothing to do with this article.
If the report came out after the impeachment article was submitted, it can't possibly be relevant to the impeachment article. This is just hearsay, the witness, part 2, electric boogaloo. And it's even worse because it's based on a report prepared by someone else, which is hearsay. The report itself is hearsay, and apparently contains statements from other people, which is hearsay within hearsay. And then some of those statements rely on the other people, which is hearsay within hearsay within hearsay. So it is just it is all the hearsay, and this is hearsay, the witness, part 2, electric boogaloo. This guy wasn't there during the time period. He doesn't know anything. It's a report prepared by some other guy that isn't relevant to the charge. It is all the hearsay. I'm kicking this guy out of my courtroom too. This guy can also eat the dirt. Do you have any relevant witnesses, counselor? You can't testify, and you can't testify. Can you find someone who can testify for me, please? Please, for the love of God. I know one guy who can testify that you've identified. Bring him. He's the guy. He's the guy. Bring him. Who are these other assholes? This guy has nothing of value to say. Watch the judge admit it anyway. Watch the judge admit this report with the 8 levels of hearsay that's prepared by another guy who isn't on the stand. Did you receive the report? I sure did. Isn't the report just the best report? It sure is. It's the best report. It makes we're really guilty. It makes sure that we're not guilty at all. It's the best report.
For the record, I had sustained that objection, and it stands. Go ahead.
May I proceed, Judge?
Pardon?
May I proceed?
You may proceed.
Okay.
Hold on 1 second. Our jurors left the building for a moment. I did not notice. Give a senator a minute, and they're gone.
Do you have any other questions? Do you have any relevant questions,
We will
Counselor?
be taking a break shortly, members, okay? We've just been back 90 minutes, and we normally take a break between 90 minutes and...
Do you have any relevant questions for a relevant witness? Maybe someone who saw something
We're still missing a few.
or observed something. I don't know. How about the first AG? How about him? He seems like a pretty relevant
meeting at
witness.
the bench
How about
compared to
calling
other
him to
ones,
the
so they
stand?
were basing their exit on their experience here in the last 2 weeks.
I could tell where it was going, so.
HPW Wise's defense can present the case it chooses. Not in my courtroom. You got to actually present some relevant witnesses. This guy is DQ'd. This guy is
Good news is the
DQ'd.
cricket also
This
left
guy
the,
doesn't get to
chamber.
testify. This guy doesn't get to
just think we're more
testify.
entertaining,
Bring
Mr.
me some
Dorfman and I,
relevant
so
witnesses.
Cricket's out of here.
Bring me some people who actually have knowledge because they observed it. Defense doesn't get to do this. Not in my courtroom. None of these people get to testify. Grant over here doesn't get to
All are
testify.
present and accounted for. You may proceed.
Thank you,
Grant,
Judge.
Grant is going
Before we
away.
talk about the internal report, I want to talk to you about your time at the Office of Attorney General in December of 2020. Can you talk to us about what was going on as far as it relates to productivity in the office at that time?
It was a very busy time.
Don't
I
put
think
that
I
on my
mentioned the
CV. I'll
Google
definitely
ad
put that
tech
on my
lawsuit
CV.
that had been
Judge
used, as I
actually
understood
does
it, in
not
the making.
allow completely irrelevant
We were
witnesses to
about
testify.
to
Film at
release
11.
The complaint at long last in federal court. It was a huge and extraordinarily complex case.
Go
You're
to the
taking
Court of
on
Appeals with
Google,
that
so I was
one.
told
Good
if
fucking
I
luck.
took the job, I would have frontline responsibility for, or at least overseeing that, and we intended to hire outside counsel. So that was a big part of that. At the time, of course, the election was still going on. There were still election challenges, and I know people were talking to the office about that. That ended up resulting in the Texas versus Pennsylvania lawsuits. My first week on the job, I think my first day on the job, we went
I'm
to
going to
lunch.
slow you down. I'm going to break that up, Mr. Dorfman. So you're talking about the election. I assume it's the presidential election, correct?
Yes.
Okay. And can you talk about the effect that that had on the workload of the Office of Attorney General at the very beginning of 2021?
You think this is all some
Well, I
secret
had nothing
plot?
to gauge it by, but it was extraordinarily
You think
busy.
the pants
time.
messed her? You
Did
think
it
this
appear
is
that
some
the
secret
morale of
plot
people
to
were working hard at the Office of Attorney
con
General?
Oh, absolutely.
the
And despite
prosecution
allegations that
into
were made against
wasting
Attorney
time
General
on cross
Paxton, people were still working at the
so
office.
that maybe that they'll
Yes,
be able
in
to
my
call
first 2
Paxton? You
weeks
think this
there,
is
I
all some sort
don't
of
think I
4D
made it home
chess?
before 8 p.m. certainly.
Did you have
any
any,
night.
sorry to cut you off, but
Okay.
did you have any concerns about the work pace and workflow at the office?
No, it was fun. I mean,
Maybe.
if that had been for the next 2 years, I would have had concerns.
Okay. As far as burnout goes or things
All
like
right.
that, were there any concerns about anything like that?
Specifically
that's a
December 2020.
possible read on the
Or
situation.
into 2021?
I'll allow it.
Yes, it's 2021.
We're trying to con the
went on.
House
Obviously, the Biden
into
administration came into
wasting their
office.
time.
Day one, people may remember this, a raft of executive orders. We were the first, and I'm proud of this, we were the first State Attorney General's office to obtain a preliminary injunction against one of those executive orders. It was the day one immigration order that imposed a 100-day moratorium on deportations, even where congressional statute dictated that removal must take place of a deportable alien within 90 days. And so we challenged that in court, federal court here in Texas, and won. And of course, there were other executive orders that we were challenging.
Burning
and
their
filing
burning
lawsuits
time, making
against.
objections. That doesn't count
I was
against
a
the
voice in the
House.
office from a beginning.
Routine
then, but
objections
throughout
count
this
against
time,
the
and
party
as we
that
continue to
presents
do
the
this,
witness,
do the
so
work,
The objections
it's
aren't enough
great
to burn their time.
Be in court. It's
would
great
only
for
be
our
the
lawyers
cost
to go
that
into
burns
court
their
at
time.
the daytime and spend the whole day and file briefs at night, but you can only do that pace for so long. So I wanted us to be careful, husband our resources, use them wisely, pick the right cases, prioritize appropriately.
Utilize your resources.
To maximize the good work we were doing,
Okay.
I thought.
Now, during that time in fall of 2020, winter of 2020, and into spring of 2021, are you guys working in the office or are you working at home at this point? Or is it a mix?
Where I was, everyone was in the office. Now, some of the attorneys in the divisions, the litigation divisions, did a combination.
Okay.
In a lot of the cases, the courts were shut down due to COVID still in many cases. So even though we had cases all over the state, you might have a hearing in San Antonio on this computer in your office, then you turn and have a Zoom hearing in Midland or El Paso 30 minutes later.
Understood. And
Which helped, less travel.
right. You said that you were Deputy First Assistant Attorney General. Are you aware of who your predecessor in that position was?
I believe it was Ryan Bankert.
Okay. Can you talk to us about your role at the time as the Deputy First Assistant Attorney General?
The core responsibility I had is to oversee the litigating divisions, both criminal and civil. As I'm not a criminal lawyer, never have been, never was a criminal judge for that matter, I rely very heavily on my criminal division deputy, it's Josh Reno, and to manage those responsibilities and report up to me and as needed. But the civil litigation divisions, I feel very comfortable overseeing them. In addition to that, I have overall responsibility at the executive level for policies, procedures. From time to time, I've also had direct report responsibility over human resources, as I do currently, and also over the communications team.
So a wide array of divisions.
Yes.
Now, are you familiar with whether at any point special litigation was under the oversight of your position, Deputy First Assistant Attorney General?
I don't think it has been since I've been there. I think it was at one time. Again, I don't know this personally.
And can you tell us now who oversees the Special Litigation Division?
Ralph Molina.
Okay. And then under Ralph Molina, or at any point in time, was it a Patrick Sweeten?
Yes.
Is he still working that position, moved to a different position?
He's currently our lead counsel in the Buoys case in the Rio Grande River, but that's on loan from the governor's office.
Did you have the occasion of working at the Office of Attorney General while he was in charge of special litigation?
Absolutely, yeah. I mean, until I think earlier this year, he joined the governor's office. Up till that point, he was there the entire time I was there.
Okay. Did you feel like you had to help him with his job, or did he appear to be qualified in handling his business in that position?
Patrick?
Patrick.
Very talented lawyer,
Okay.
very experienced, very capable. If I had one criticism of him, it's that he's in court more and managing less. We wanted him to clone Patrick Sweetens, so we had a team of Patrick Sweetens, but Patrick's so good and so natural in the courtroom, I think he longed to be there.
Okay.
Maybe you should have gotten Patrick here.
Patrick is the kind of guy that takes pressure off you if you didn't have to watch the Special Litigation Division?
Certainly. They're the Special Litigation Division for a reason. I think that was a creation of Attorney General Abbott to have the tip of the spear. We have a lot of litigating divisions. We have our General Litigation Division, which are outstanding. All our divisions are very good, do different things. And special
Thank you for the
litigation is
$4.99 super chat. Appreciate
the
it.
courthouse in 30 minutes. We just found out the Obama administration's filed doing this. They've issued that executive order. No time, let's go.
Okay.
And so if I had to oversee that as well as everything else, you're right, it would put more pressure on me.
I want to fast forward and talk to you about the internal investigation report. You said you had no personal knowledge of the contents or the subject matter of that report, right?
Say that again, please.
You had no personal knowledge. You weren't personally there for the subject matter that is in the internal report authored by the Office of Attorney General.
I wasn't there at the time these events happened.
Were you present at the Office of Attorney General when the report was being drafted?
Yes.
Can you talk to us about who was responsible for that, and if you know what process went into drafting that report?
I think in the first instance, we relied on an office-wide forensic compilation of documents, emails, et cetera, that were relevant. Brent Webster took the lead in compiling that, And then we had a team, and again, as early as January, I was editing drafts with others, Josh Reno, later Murtaza Sudarwala, our deputy for legal policy, Austin Kinghorn, Enrique Varela. There were others, but I may have left them out.
Okay. And can you talk to us about what your role was with regard to the publishing of that report, or at least getting the report ready to be published?
Well, I don't think we published it until August of 2021, and that probably is a reflection, one, of just how busy the office was and how much other stuff there was to attend to. But I'm sure I had revised and edited and redlined at least 5 or 6 times the entire document front to back.
Okay. Now, understandably...
and others did as well.
Right. Understandably, you weren't present for these events that the document summarizes. Did you play a hand in trying to find documentation to support the positions taken in that report?
More oversaw that process.
Can you talk to us about your oversight of that process?
Yeah, I felt very strongly this had to be, it was going out as a report of the office. I believe the Attorney General had said, look, these allegations are baseless, and I will investigate and present the facts and let the voters decide. Words to that effect. I wasn't there. And so this was a fulfillment of that commitment. I took that as a charge to lay it out there. And I think it's fair to say that the document, my emphasis throughout this process of editing was, look, this needs to be the voice of the agency. It's not any one person. It's all of us, and it's objective. It's factual, both in tone and substance. If we make a conclusion or from the facts that we presented from the documents that isn't supported by the document, let's not make that conclusion. Let's take that out and let the people reading it make their own decisions.
And so really, you're just trying to make sure that they're not making allegations that they can't back up.
Objection, leading.
Sustained.
Would you agree that your job was to make sure that the claims were verified?
Same objection, Your Honor.
Sure. Was it your job to make sure that there was evidence or at least something to corroborate statements that were made?
Was there an objection there?
Not to that, Your Honor.
I didn't think so. Okay.
I certainly viewed that as my job, yes.
All right. Now, you mentioned earlier that at some point you get involved into the lawsuit in this case, and I want to talk to you about the lawsuit, okay? Can you tell us your understanding of when the whistleblower lawsuit was first filed against the Office of Attorney General?
I think it was November of 2020.
Okay. Can you tell us who the named parties within that lawsuit are?
I'm going to struggle on their first names.
No problem.
Ryan Vassar.
Okay.
Mr. Maxwell's first name is
David Maxwell.
David Maxwell, thank
right.
you.
Mark Penley, ring a bell?
Mark Penley and Blake Brickman, sorry.
Okay. And more focused on who is the named party or the named defendant in that lawsuit?
There's just one defendant, the Office of the Attorney General.
Okay. Was Ken Paxton specifically named as the party to the lawsuit?
No.
All right.
No,
So it's the
because
Office of
that's not
Attorney
the nature of the
General
lawsuit.
on the filing.
Yes.
Right.
And
It's
what is the
office.
first thing that you all do? Who all is working on the lawsuit with you at this time?
About the same time I was interviewing, I think they were interviewing for outside counsel, so I knew Louis Brisbois had been hired, and either the first or second week we might have had a phone conference or meeting with them. At that point, I think the lawsuit had been amended at least once. There was later a second amended, and so I was working on it. Austin Kinghorn was working on it. The first assistant would have been involved.
How about Chris Hilton? Was he working on it?
I think that's right. I think Chris Hilton was also from the start there. He certainly was later.
Sure.
Enrique Varela as well, who worked with Austin Kinghorn.
And I'm going to cut you off. You mentioned Louis Brisbois. Can you explain to us what Louis Brisbois' job was with regard to the whistleblower lawsuit against the Office of Attorney General?
To be outside counsel, Bill Helfand is an attorney I've known in Houston for at least 20 years. Very good lawyer, specializing in government work, especially defense like Section 1983, federal court lawsuits, many of which, if not most, have an employment quality to them. The sheriff being sued by his deputy, something like that.
And just without getting into the contents of the document that I showed you earlier, the Lewis Brisbois report, was that authored by the attorneys that were outside counsel for the Office of Attorney General?
Yes, Mr. Helfand and others.
Okay. Now, in that litigation, did you all file a plea to the jurisdiction?
Yes, we did.
Okay. Can you explain to us what a plea to jurisdiction is?
A plea to jurisdiction is a document that says to the court, every court must first assess whether it has,
Speaking of the microphone.
every court must first assess, that was too loud, whether it has jurisdiction to entertain a lawsuit. And the state of Texas cannot be sued for money damages without its consent. And this body and the House are the ones that must expressly waive by statute the immunity from lawsuit, the sovereign immunity of the state of Texas, in order for a plaintiff to recover money damages. They argued, the plaintiffs in this case, that
I'm going to stop you and I'm going to break that down. You know, I didn't go to Yale, so you got to make it slow for me. Mr. Arroyo, would you please put up Article 8 onto the overhead screen? So essentially, plea to jurisdiction, well, let me ask you this. Is that something that is commonly filed in lawsuits in your experience as a civil litigator? Or at least with regard to Office of the Attorney General?
I was going to say, at the Office of the Attorney General, I'd say probably 90% of our defensive cases, at least the ones I'm most familiar with, we file a plea to jurisdiction. Almost every case challenging the most recent enactments of the legislature arising out of the last session, which have been, all those legal challenges have been brought in the last few months. We filed pleas to jurisdiction, I think, in every one of those, saying this suit can't go forward, the court has no jurisdiction, the state is immune.
Okay. Now, Eric, if you could just blow up the second paragraph specifically all the way down to, well, this part's fine right here. If you could blow that up. Okay, so I'm just going to read the Article 8 to you, Mr. Dorfman, which states that specifically Paxton entered into a settlement agreement with whistleblowers that provides for payment of the settlement from public funds. The settlement agreement stayed the wrongful termination suit and conspicuously delayed the discovery of the facts. The next page goes on to say, and testimony at trial to Paxton's advantage. Sorry.
Let it get up on the screen. Yep. Okay, continue.
The Paxton's advantage, which deprived the electorate of its opportunity to make an informed decision when voting for Attorney General.
On Twitter, I might have in the past.
At what time?
But I haven't really thought about doing it on the regular.
The lawsuit was filed in November of 2020. When was it that the Office of Attorney General actually files the plea to jurisdiction?
Not exactly sure, but I believe it was January of 2021.
Okay. And when did the Office of Attorney General engage in settlement agreements with the whistleblower plaintiffs in this case?
Almost exactly 2 years later.
Okay. So when we're talking about the plea to jurisdiction, we are 2 years before settlement discussions even come into play, right?
Right.
Now,
I mean, I guess I could stream both if I set it up properly.
I think in your motion
really
for plea to jurisdiction, it was in two parts, correct?
I'd have to see it.
Well, did you talk about
I'm not sure
sovereign
there'll be
immunity?
any real benefit to it.
Absolutely.
Can you explain to us how sovereign immunity comes into play in your plea to jurisdiction?
Well, I think I've covered that. The state is immune from suit unless there's an express statutory waiver from the legislature.
Okay. And then the second part of that was that you talked about separation of powers.
Yes.
Can you talk about that to us?
Well, let me go back and cover the first one, if you don't mind. May I, Your Honor?
If you please go back and cover
I need to qualify my comments. What you're describing is, you've reminded me and refreshed my memory that yes, the Whistleblower Act is exactly the type of express statutory waiver of sovereign immunity that allows one to sue the state, in this case for money damages. But the case law has been clear, and we argued it, that unless you meet all the elements of a Whistleblower Act claim, there is no waiver of sovereign immunity. There's no jurisdiction for the court to proceed. And we alleged that the plaintiffs in the case had not met their burden of establishing all the elements of the whistleblower claim, and therefore sovereign immunity still applied.
Okay. And was that file in the plea to jurisdiction, was that made in good faith and based on your legal research?
Yes.
All right. Now I want to focus back onto the article. that states specifically, if you'd go back to the other page, Eric. It talks about, and you zoom in, the settlement agreement stayed the wrongful termination suit. I just want to be clear, when you all filed the plea to jurisdiction, that had nothing to do with the settlement agreement, right?
We weren't even discussing settlement at that time, no.
Okay. Now, what is the result of a plea to jurisdiction with regard to discovery in a lawsuit?
The plea to jurisdiction, again, every court must first assess whether it has jurisdiction. If it doesn't, it's powerless to order discovery or proceed any further. And the legislature has passed an interlocutory appeal so that even if we lose the plea to the jurisdiction, if we win, the case is over and dismissed. If we lose the plea to jurisdiction, we have the right to immediately appeal when normally you would have to wait till the end of a case to file your appeals. And the intermediate appeal stays the court's jurisdiction. It can't proceed further in any capacity until the appeal is resolved.
Okay. Now, was that plea to jurisdiction filed to stop the discovery getting out to the public in this case?
I don't understand your question.
You just said that a plea to jurisdiction essentially stops the discovery from occurring in a lawsuit, right?
It stops anything from occurring in the trial court.
So my question to you is, when you all filed the plea to jurisdiction, did you do so because you felt that the law applied in that situation, or did you do so because you wanted to stop discovery from getting out to the public?
We did it because we thought the state had sovereign immunity, and it was our duty to assert that, as we do in so many of our cases. That does have the effect of stopping discovery from going forward and saving the taxpayers the expense of that discovery and our lawyers the time that, discovery really is where the time gets taken in trial cases.
Okay. I want to talk to you about the procedural posture of the plea to jurisdiction. Can you talk to us about the first court that ultimately ruled on you all's plea to jurisdiction in the whistleblower lawsuit?
The first court?
Yes.
That was the Third Court of Appeals here in Austin.
Well, did it go to the district court prior to that filing?
I'm sorry. Yes, you're right.
Can you talk to us about that?
We had some discussions back and forth. I don't know how much detail you want to go into, but with the plaintiff's attorneys about scheduling a hearing on two things. They wanted to have a temporary injunction hearing. I think initially they said they needed 4 days. The only purpose of a temporary injunction hearing in this context would be for Mr. Maxwell and Mr. Vassar to seek reinstatement under the Whistleblower Act. So to be reinstated to their position with the Office of the Attorney General.
So are you saying that Mr. Maxwell and Mr. Vassar actually wanted to come back to the Office of Attorney General?
Yes, and I think that's still in their live pleading. Okay. Well, they're pleading, I shouldn't say live.
Right. Now, what was the ultimate decision by the district court with regard to that plea to jurisdiction?
Well, so we were trying to schedule the plea of the jurisdiction before, 1 week before, something, 1 day, whatever, because the court can't have a temporary injunction hearing until it's heard and ruled on the plea of the jurisdiction. The plaintiffs requested and the court agreed to set them on the same day, but that had the effect of meaning before the judge ruled, we were set to a temporary injunction hearing, which got underway and started. And there was even testimony taken, I think, from Mr. Mateer for some time before we got the Court of Appeals to agree that by proceeding with the temporary injunction, she had implicitly ruled, the judge had implicitly ruled that she had jurisdiction. And
so ultimately, and I'm going to cut you off, ultimately the case goes up to the Third Court of Appeals?
Yes.
Okay. So the district court didn't rule on the plea to jurisdiction necessarily?
I'd have to go back and check. I think she may have written an order expressly denying it, but not until after we had already gone up to the third court and said, we need intervention.
Okay. And can you talk to us about what happened at the Third Court of Appeals?
They said oral argument, and I can't remember exactly when that was, but I believe it was October of 2021 when they issued their opinion, maybe 30 pages.
So almost a year later, while that plea to jurisdiction is still pending, right?
Well, the plea would have been filed in January, I think, and so you're talking 9 months later.
Okay. And can you tell us how the court ruled, the Third Court of Appeals ruled?
Third Court of Appeals agreed with the plaintiffs that the trial court had jurisdiction, that our reading of the Whistleblower Act on the two prongs you mentioned was wrong. Well, they disagreed with it.
Okay. And in response to the Third Court of Appeals ruling in that case, what did you all do on behalf of the Office of Attorney General?
We appealed that to the Supreme Court of Texas by filing a petition for review, asking them to take the case and reverse the Third Court's ruling.
Okay. Now, do you recall when the appeal to the Supreme Court of Texas was filed?
Not exactly. It would have been within 30 days, maybe 45 of that October, I think 2021 opinion from the Third Court.
Okay. And at this point in time, what is going on with the litigation in the whistleblower lawsuit?
Only the appeals process.
Counsel, excuse me, I'd promised a break about 15 minutes ago for the jurors. They've been in a 2-hour sit down.
That was an okay time
Is
to
this a
stop,
good
Your
time?
Honor. Sure.
I don't want to interrupt, but it's a good time. Members, it's 5 minutes before 4. Come back at 4:15, 20-minute break.
Yeah, so I don't necessarily have a problem with this, but I have already sort of scored this for the AG, so the AG isn't scoring any points because I already
We'll stand at
scored
ease.
for the AG in the first instance. They're trying to talk about the issue of Ken Paxton delaying the discovery, but the way it's written in the impeachment article is legally wrong. So it wasn't the settlement, because the way it's written in the whistleblower statute, or the way it's written in the impeachment article, is that it was the settlement that stalled discovery, but it's not. As he is pointing out quite correctly, it was this motion for jurisdiction that prevented the discovery from going forward, not the settlement. So the charge as laid out in the impeachment article was ill-advisedly drafted and is legally deficient. So they've already convinced me as to this charge. So I find him credible. It just doesn't particularly help because I already scored this in their favor. So they can spend more time on it if they like. I mean, obviously, I'm speaking for myself, not for the jury and what they think the jury does or does not believe. But for me, this is legally deficient, and so I've moved on in my mind. So if that matters. This guy has nothing to offer about why the whistleblowers were fired. He wasn't there. So, I mean, I guess they can talk about their legal thing, but yeah, so far he's not offering any testimony that's relevant to any charge that I care about. So that's where we're sitting. Is the appeal still ongoing? I don't know. I don't know if that's still ongoing. I don't think so. I don't think the appeal is still ongoing because I know at some point they entered settlement conferences. So I think the Supreme Court either denied or confirmed the Court of Appeals because otherwise they wouldn't have entered the settlement conferences. So I know that at some point they had a settlement conference because that's part of the issue is that he tried to settle with taxpayer money. So the Supreme Court of Texas did rule, just not where we are in the timeline on the testimony. So, yeah. So it's not still going through the appeal process on that issue. I don't know where the whistleblower lawsuit is procedurally at this point. But, yeah. Sandy sent me some gifts. We do appreciate it. England DJ said the soundtrack of this impeachment should be Mana. Dedra Simmons has been a member for 7 months. Chuck in Tennessee has been a member for 10 months. Burger King 23 became an uncivilian. Thank you for hitting the beautiful, beautiful join button. Sandy gifted 10 gift memberships. DSN gifted $4.99 and a super sticker. And that is appreciated. If they decide to settle, it would be over. With respect to them, sure. It would be over with respect to their claims. Yeah. But it doesn't mean that they weren't improperly fired in the first place. Dr. What evidence was presented by the House to prove whistleblower were fired without cause? Either you're not paying attention or you're trolling me. Either way, I can't be bothered to answer your question. Two years, isn't that illegal? Seems like they have selective laws. No, not really. Not in and of itself. The appeal process can take a long time. Did they say they wanted the opportunity to get their jobs reinstated? Yes, in their lawsuit they did. They said they were dismissed for cause. They want their job back. Why do they ever want to come back? I don't know. Because they were doing a good job and they liked working there and they want to continue working there. They feel they're wrongfully terminated. They want their job back. It's not an uncommon thing to ask for. It's not an uncommon thing to ask for in wrongful termination cases. I can't speak to how it would be resolved in this case, but I can tell you, like, it's not uncommon to see a wrongful termination case where a person was fired illegally and they want their job back and they get their job back and they get, like, all the salary for all the years they should have been there, plus, like, whatever promotions they would have been in. You have to put them back in the same place they would have been in. So you give them all the salary they would have gotten, plus whatever promotions they would have otherwise gotten, and that salary, plus. And, like, you put them back in their position, and, like, yep, they just keep chucking on. It's not uncommon in unlawful termination cases. I have seen it happen. Is there any other questions that I can answer? How's the trial different than a regular jury trial? It's different in a lot of ways. It's a political trial that's also quasi-criminal. The rules of evidence are adopted by the Senate, and the questions, it's different in a lot of material ways. It's a difficult question to answer. The rules are made up and the points don't matter. So, like, sort of like, it's more, what would you say? It's more ad hoc than a typical trial. Like, normally, like in a normal court, this trial is just like every other trial, right? Of course, the facts are different, but the trial itself is the same trial. Same different day, different day, same song. And it's the same thing we saw. It's the same thing we saw yesterday. It's the same thing we'll see tomorrow. The details matter, but not in a way that matters for the procedure. This is ad hoc. We're making it up as we go along. The rules are made up. Everything is chaos. What's the best side dish for a nice grilled steak? Asparagus. You could do some bacon wrapped asparagus with some butter. Grilled asparagus, 100%. How's my improv class? It was canceled this week due to some sort of COVID thing. Apparently, some of the members came down with COVID and they canceled class, which was lame. Will I cover the Trump impeachment case? Yeah, if I can, certainly. Did the HR guy make number 6 a better item? Yeah, the HR guy was more helpful for the prosecution than the defense in the end. What time do I need to stop today? Sometime about 6 o'clock. 6:15. Something in that time frame. Hopefully they won't call the Attorney General to stand. Watch them call the AG to the stand and me have to leave. That would just be the kick in my teeth. Let's see, what time do I need to leave here? I need to leave here. Yeah, at about 1:15. I need to leave here at about 6:15. Is Paxton in jail? No, this is not criminal. There's no criminal exposure. Which do I prefer to do? Defend or prosecute? Well, at this point, I'd want to take on the prosecution's argument because I think I could do better. You know, the prosecution needs help. So at this point, I'd want to take on the House manager's case because I think I could make it work a bit better. Could I really excuse a witness from a stand if I think they have nothing to offer? As a judge? Yes. Absolutely. Yeah. You can. Judges have a fair amount of power in their courtroom. They can absolutely tell you, you're not calling that witness. This witness is a bullshit waste of the court's time. You're not calling that witness. I really want to. No. But I really want to. No. So in principle, can you? Yes. If you get to it and you're like, this witness is an absolute waste of my time, I can't be bothered, go away. Yes, technically you can do that. You know, you want to reserve that for, you know, special occasions, but yes. Yeah. Judges get a lot of discretion and sort of they get a lot of discretion in like what witness testifies, as to what, the scope of testimony. They get a lot of control over their courtroom. And as long as, you know, they're not acting arbitrarily, as long as they're not clear error, as long as they're within their discretion, judges get a lot of latitude. Once again, rule number 1 of litigation, don't piss off the judge. Because the judge can help you or they cannot. And if the judge is against you, they can make your life very difficult. So, rule number 1, don't piss off the judge. It's a good rule to remember. I think the 6th article of impeachment is the best. The retaliation against the whistleblowers is the best. If they don't call the first AG to rebut the retaliation claim, they have a real problem. I don't know why HR guy is there. HR guy is a waste of my time. Sour cream on a loaded potato? Yeah, I think sour cream on a brisket loaded tomato. That sounds good. Will the defense team try to rattle the prosecution's clock? I don't know if that's what they're trying to do. I don't know if they've been particularly effective at it in trying to round out the prosecution's clock. I don't know if that's what they're trying to do, but Dinesh D'Souza's judge told him not only could he not call witnesses, but he couldn't present defense of unequal application law. That's a tough defense to offer as a matter of law. If you're like trying to do a selective prosecution argument, that's really tough. So it isn't particularly surprising, right? So yeah, it isn't, you know, if it's not a legally cognizable defense, the judge can deny you the defense because it's not legally cognizable, and sufficient evidence to prove selective prosecution is going to be very, very difficult within a legal sense. So that's not particularly surprising. Would I look down on pro se litigants? No, I wouldn't look down on pro se litigants. I look down on the sovereign citizens. I will hold them in contempt. They will spend time in jail. I'm going to have a sign outside my courthouse. We'll figure out the exact language. It says, if you breathe soft sit, you will be found in contempt. And then they breathe soft sit, and I will absolutely hold them in contempt. You don't have power over me. Let me demonstrate that I do. The soft sit says, you don't have authority over me. Let me prove my authority. I will demonstrate it to you very directly and unambiguously. It's a teaching exercise. Georgia judge shuts down DA effort to try Trump and co-defendants together. It's not particularly surprising that there would be motions to sever and that they'd be granted. I'm still surprised Trump has not apparently filed a motion to remove. I'm very surprised about that. Has anyone won a sovereign citizen case? Only in spite of themselves. You know, it isn't because they're a sovereign citizen. But, you know, if they're legally in the right, the judge will rule for them, which of course just makes them think, oh, I'm a smart guy. So yes, occasionally sovereign citizens do win their case, but it's not because they're sovereign citizens. It's because of some other problem in the case, which doesn't do anything to like help the cause, but yeah. Am I traveling to the Nashville meetup? I'm planning on it. It's going to be one hell of a long drive, but I'm planning on it. I think I'll leave tomorrow evening sometime. We'll stream, and then we'll probably end tomorrow at 7, and I'll probably get right on the road and drive for a couple hours and crash at some hotel somewhere, and then complete the rest of the drive so I can make Nashville. So that's sort of the working plan. Thank you for the $50 super chat. It's very, very thoughtful. I can book a flight on Delta through Atlanta for $365. I probably should take that. So let's see, I can be there if I fly out Saturday, the 16th, because this event is at 7 o'clock. I could fly out through Delta at 11 in the morning on Saturday, be there at 3 in the afternoon on Saturday, and then come back 5 in the morning the next morning. Brutal. I wonder if we could do anything other than like the earliest flight known to man. Could we like make it like 9 in the morning for the return flight? Let's see. Could do like here's one at I'm not really good at booking flights. I don't like flying very much. Let's see. Here's one that flies out at 3:49 on Saturday. That arrives too late. Here's one that goes at 8 in the morning. Comes back at 4 in the afternoon the next day, connecting through Cleveland. Long layover, though. So CLT is at Cleveland? Charlotte Douglas. Oh, that's North Carolina. It's an interesting connection. Austin to North Carolina, back to Nashville. Trump did file a motion to dismiss charges in Georgia election case. Yeah, but did he file a motion to remove? Because if not, he really should. I don't like booking flights. I don't know what it is. I just don't like booking flights. I just don't like spending money on air flights. I don't think. I don't like flying very much. Thank you, $10 from Peter. Appreciate it. It's your first super chat ever. I appreciate it. Because Nashville's like 12 hours from me. It's a long drive. $12 hours and 30 minutes to drive it. That's a long drive. Leave the night before, get a cheap hotel? Yeah, I probably will. So that's streaming all day on Friday, probably. Because the way this trial is going. Ending at 7. Getting on the road. Doing like 3 hours. And like staying for a night somewhere north of Dallas or something. I can do it for $400. Return flight at 4 o'clock in the afternoon through North Carolina. Let's see. 8 a.m. flight, arrives at 2. And then back at 4 o'clock the next day for $400. It's probably worth my sanity. I bet you Southwest is no cheaper. Let's take a look at Southwest. Let's take a look at Southwest. Let's see. We want to depart on the 16th and we want to come back on the 17th. Let's take a look. Oh yeah, these flights are way too expensive. These flights are ridiculous. Yeah, Southwest is going to cost me $650. Yeah, Southwest is not going to work. Southwest is expensive. I don't know if I'm going to make it or not to Nashville at this point. I honestly don't. Don't express pro-life beliefs or they'll fire you at Southwest. I remember that case. The woman sued. She won. You can't fire people for religious beliefs. It was a wrongful termination case. I don't know. Is Nate going? Nate is not going. He's unable to make it. I have every airport within 70 miles of my home selected. I guess we could go, we could try flying out of Dallas. Or Love Field. Yeah, we could try flying out of Dallas, Fort Worth, or Love Field. I already have San Antonio selected. That's even worse somehow. Dallas is 3 hours from Austin. That's true. I could fly out of Houston also. Yeah, for some reason it's not giving me like even the options I had before. I hate flying. I could take Greyhound and be there in 27 hours. I can do Greyhound for $350 round trip. What a deal. Megabus? Megabus actually wouldn't be bad. I don't know if Megabus would go that way, but that's actually not the worst idea I've ever heard in my life. I had a good experience one time with Megabus.
Bailiff can bring in the witness, please.
Nah, it doesn't do it to Nashville. Amtrak? That's a good idea. Let's see what we can do about Amtrak. Get business class. Amtrak.
We have all the jurors. Mr. Asso is the correct pronunciation. I want to be sure I have that right.
Thank you, Judge. Mr. Dorfman, we were just talking about the effect that a plea to jurisdiction actually has on the discovery in the case. Now, I want to focus, Eric, if you wouldn't mind focusing on the next page, top paragraph, which is the bottom paragraph of Article, bottom paragraph of Article 8. I want to read that to you. testimony at trial to Paxton's advantage, which deprived the electorate of its opportunity to make an informed decision when voting for Attorney General. Now, throughout the course of the lawsuit that the whistleblowers filed, are you aware of whether specific facts or allegations became public? And could you turn your mic on, sir?
Yeah, that won't work for my purposes, but it's
Better?
nice to do.
Okay, I'm going to re-ask that question.
Please.
Were you aware of whether the specific facts or allegations with regard to the whistleblower suit became public?
Yes.
Can you tell us about in which ways, if you know, they became public?
Well, we talked about that earlier before I came to interview at the office. There were news stories that contained allegations made by the whistleblowers. It was about that same time, maybe a little later, that the lawsuit was filed. That was a news story and a very detailed
I'll be right back.
state court petition that's public record, public filing, covered in the press accounts. And then I think they amended that petition twice between the original filing and early February. So there was a first amended maybe in December, and then in February, just before the plea of the jurisdiction hearing and the temporary injunction hearing, they filed a second amended petition, which I think is the last one. But that's 63 pages, very detailed allegations.
And I'm going to
Public
stop you
record.
real quick just to clarify. When you say they filed and amended petitions, can you talk to us a little bit about, well, who filed those petitions?
The four plaintiffs through their lawyers.
So David Maxwell, Mark Penley, Ryan Vassar, and Blake Brickman?
Yes.
And did those petitions include specific facts that they were alleging
Yes.
Attorney General Paxton and the Office of Attorney General committed?
Yes.
Okay. And those pleadings were actually available to the public, correct?
Yes.
You can look them up online?
Yes.
So, Eric, if you don't mind going back one page to the bottom paragraph, bottom clause. Article 8 alleges that Paxton entered into a settlement agreement with whistleblowers that provides for payment of the settlement from public funds. The settlement agreement stayed the wrongful termination suit and conspicuously delayed the discovery of facts. Is that allegation true?
No. Can I explain?
Please do.
The settlement agreement didn't stay the wrongful termination suit. It was on appeal, and our petition for review was pending with the Supreme Court of Texas. That court doesn't have to take any case it doesn't want to, so you have to convince it to take the case. We had made a case. Filed 2 briefs to do that.
I'm going to stop you because we're going to get there, and I want to break that down.
Sorry.
But with regard to conspicuously delaying the discovery of facts,
The settlement agreement didn't do that.
and weren't the facts available to the public at this point anyway?
More than we discussed. Obviously, the petitions I mentioned, but the Court of Appeals decision is 30 pages and has bullet point block paragraph recitals from the pleadings. So it was restated the most serious allegations that the complaints, the petitions made, were restated in the Court of Appeals decision, which also garnered news attention when it came out.
Right. And you had talked about, I think, opposing counsel actually held up a document that was the Third Court of Appeals decision against the Office of Attorney General in this case, correct?
I'm sorry, what was your question?
Essentially that the Third Court of Appeals ruled against the Office of Attorney General.
Correct.
So you filed what with the Supreme Court?
Petition for review. An appeal, notice of appeal of the Third Court's decision with a petition for review asking the Supreme Court to take the case.
Can you explain to us, I deal predominantly with criminal law. Can you explain to us kind of how the process works when you file a petition for review with the Supreme Court of Texas?
It's in the form of a brief, very much like what we would call a merits brief, but it's not. It is simply an argument for why this case is sufficiently important to be one of the 100 or 110 cases that the Supreme Court can take from the entire state and rule on. They only hear so many oral arguments or take so many cases. So you have to convince them this is worthy of their attention. We tried to do just that.
Okay.
And by our opponents filed a brief between our initial and reply brief explaining to the court they should not. They should let the Third Court of Appeals case stand, in which case the case would have then gone back to the trial court.
Okay. And so the Third Court of Appeals ruling was actually up for appeal, right?
Yes.
Was that ultimately ruled on, that appeal?
Not to this day, no.
Okay. Can you talk to us, are there certain sessions or time periods where the Supreme Court tends to hear cases?
I think that's right. I would defer to people, bless you, who argue in front of the Supreme Court for a living, but yes.
Okay. Do you feel that, I guess at any time, the Supreme Court can pull your case out of a hat to hear it, right?
I think that's right. They usually confer as a body, I think in person, although maybe by remote sometimes too, especially during COVID.
Okay. Does that have an effect on your ability to negotiate or work out a settlement with another party? Or does it affect the other party's maybe goal or them wanting to settle?
I don't know what the what is in your sentence.
The potential for the Supreme Court to pull your issue out of a hat and have it come before them.
Absolutely. It's a significant moment in a case. If they take it, I think the conventional wisdom would be they're not taking the third court's case if they decide to take it to affirm it, because they could just do that by denying the petition for review, save themselves time.
So what does that mean to you in the event that they might decide to take your case for review?
It would have altered our assessment of the case and made it, we would have felt very good about our chances for winning the appeal and dismissing the case outright.
Would that give you the upper hand potentially in settlement negotiations?
So much so that it might make settlement impossible.
Okay. Do you think, if you know, that that had any effect on this case coming to a settlement, or at least settlement discussions starting in this whistleblower lawsuit?
I think that's why settlement negotiations started.
Okay. About what time did settlement negotiations actually begin in this case?
I'm not sure whether it was the very end of December or the first week or so in January of 2021, but about somewhere in that time.
2021 or 2022?
Sorry, 2023.
2023.
December 2022 and January 2023, thank you.
And just to clarify for the senators, the petition for review probably sat with the Supreme Court for quite a while, did it not?
Yes, I think we filed our initial petition, initial brief in July of 2022.
Okay. Who reached out to who to discuss settling the whistleblower lawsuit?
They reached out to us, my recollection.
And when you say they, you mean the whistleblower's attorneys?
Yes.
Okay. And can you talk to us about when, if you know, when that occurred?
Like same time, late December, early January of 2023.
And what did you do in response to them reaching out?
We discussed internally whether we wanted to, as they were requesting, go to mediation with a professional mediator in the Austin area.
What kinds of things were you discussing within your office as to why or why not settle a case?
We certainly wanted to discuss the pending petition for review and when it might be ruled on and what that might do to the party's willingness to mediate at that point if it happened. Whether we could get a professional mediator worth his or her salt on that short a notice, because I think the plaintiffs wanted to mediate in the next 7 to 10 days, maybe 14 at the outset, at the latest, because they were concerned that the Supreme Court might rule, and either way it ruled, the other side would feel good and the other side would feel bad and maybe couldn't. So risk creates settlement potential. So that would take out some of the risk.
Risk for the plaintiffs, right?
Risk to the plaintiffs that the court would grant it, and that might indicate their case was going to be dismissed maybe in a year, maybe in 9 months. They may have assessed it differently. That's how I would have seen it. And risk for us that if the court declined to accept our petition for review, the third court ruling stands, and we're back in trial court, and we have years perhaps of lawsuits and appeals, litigation and appeals, and the accompanying expense and time.
Who found the mediators?
The plaintiff's lawyers did that. I remember clearly because I was very skeptical that that short a notice we would get any good mediators, and they told us in response to that, I think that not only they had 2 or 3 who had available dates in the next week or 2, which indicated to me, I told people at the office, that's a good sign that they're eager to mediate, because they must have called 10 or 12 people if they could find 2 or 3 available on that shorter notice.
Okay, so it appeared to you that they intended to reach a settlement.
I think they were highly motivated to settle.
Okay, and that's based on your years of commercial litigation experience, I assume?
And as a mediator and trying to get a mediator on short notice.
Fair enough.
In fact, that was kind of my specialty, is I didn't mediate full time, so if parties couldn't get one of the regular mediators, they knew I was probably available.
Now, I want to zoom out a little bit, just generally speaking, in your years of experience in both a mediator, a judge, and a litigator. Does a party's willingness to settle a case indicate that maybe they think they're liable, or that they think that the other party is correct? Can you talk to me about that?
Sure. In my experience, especially mediating and representing parties who mediate their cases, both sides at least will say they like their case, and they frequently do. Mediation takes place when there's risk and uncertainty, and the only way to control the outcome is for the parties to reach an agreement and take it out of a jury's hands. You never know what a jury's going to do. You don't know who the jurors are. And it may be 2 years from now. It may be, again, 12 people pulled off the street. That's, if you want to subordinate your control of your affairs to those people,
I think
that's
getting
your
my
choice,
policy
but that's
license someday
expensive
would
and
be
risky.
cool.
Okay. And
I mean, it's an expensive proposition, but
Did
maybe
I answer your
someday.
question?
You answered my question. I appreciate it. And I want to bring actually your answer and apply it to the fact of this case.
Uncivil Airlines.
Did you have a conversation, without
Airlines.
getting into specifics, with other OAG employees about settling, or at least going to a mediation with the plaintiffs in this case?
Oh, yes.
Okay. Now, when you entered those discussions, did you have a viewpoint on the strength of your case for the defense, the Office of Attorney General in this case?
Yes.
And what was your viewpoint?
Well, we hadn't probably looked at it in some time since filing the briefing, so we reconvened, revisited, reminded everybody where things were and what the arguments were, so we could assess that. I remember being a voice, as I am generally and maybe professionally. Look, let's go to mediation compared to years of trial and discovery and outside counsel on both sides. The expenses, the time is short. We can do it in a day, maybe 2. And the expenses, a rounding error in the budget, it's the responsible thing to do, especially in this case. It's one thing if you're a private plaintiff or defendant. It's another when you are dealing with the state's money. I think I felt and articulated that we kind of have a duty to explore settlement. Maybe it can't happen, but we should give it a try.
Right. Your Honor, at this time, may I approach the witness in the court and opposing counsel?
So I was unclear on something, so maybe someone else who was listening can help. Did the Supreme Court deny review, or is it still technically pending at the Supreme Court? Because I was confused. So, help. It's still pending? Really? All this time? Still pending? Damn. What is the Supreme Court of Texas
Mr.
doing?
Dorfman, I'm showing you what's been pre-marked as Attorney General Exhibit 335. Do you recognize this document?
Yes.
And what do you recognize this document to be?
This is an internal memo prepared by Chris Hilton, the chief of our General Litigation Division, assessing after we'd received settlement statements from, I think, 3 of the plaintiffs in the Whistleblower Act case, explaining why they thought their case was strong and what they thought they would recover at trial.
And let's not talk about the contents of the document, but could you tell me when this document was authored?
This, on its face, it says February 1st, 2023. I don't have any reason to doubt that's the date. That's the date, by the way, we mediated the case.
Okay.
So whether it was circulated before that date in draft form, I think it was, my recollection. We certainly discussed the contents of it internally before it was put into final form.
Okay, and did the findings, without getting into what the findings were or the subject matter of the document is, did this have an effect on your mindset going into the negotiations?
I don't know if it certainly informed me, and I relied upon it, and had I think it summarized the state of play well.
Okay. And is AG Exhibit 335, is that a fair and accurate copy of the memo that you received from Chris Hilton?
Give me 1 second.
I have no interest in covering the Murdaugh financial crimes. He's completely guilty, and if it goes to trial,
Yes.
I mean, it's going to be a slam dunk.
Your Honor, at this time, I would offer AG Exhibit 335 into evidence.
Any
Mr. Ross,
objection?
I just want to make sure I have the right document. Is this the one with the AOG seal, but with Ken Paxton's name removed?
Yep, that's it.
Then no objection.
Admit
May I proceed?
335 AG exhibit into evidence. You may continue.
Thank you, Judge. Now, I don't want to go line by line in this report, but would you mind just summarizing
Nice little burn there.
kind of what this document is and what you and Mr. Hilton's thought process was with regard to the financial aspect of this mediation in the case?
Sure, it's important to
Thank you for the
realize
$25 via
mediation, we were
Venmo.
told in no uncertain terms Blake Brickman would not participate in mediation. He would not come to mediation. He would not be there. He was going to trial come hell or high water. So the opportunity was to settle with 3, not all 4 of the whistleblower plaintiffs. And so we received settlement statements from demands, basically. This is what we're going to present the week before, maybe a few days before the mediation date. And this was kind of a summary. I think collectively their attorneys argued for over $5 million in damages if they settled today. Of course, prejudgment interest and attorney's fees, as they said, would go up if the case continued, et cetera. But so for 3 of them, that was and we didn't want to take their word for it, so we asked one of our top attorneys to read those carefully, review the case law, and report back on what we would consider a more realistic assessment of the case's value was.
Okay. And just a brief question. This is just an inter-office memorandum, right?
Yes.
Objection leading.
Was this,
Overruled.
I'm going to ask the question again. Was this an inter-office memorandum?
Yes.
Did you send this out to anybody outside of the Attorney General's office?
No, we would not have done that.
Did you represent that you were the Attorney General or that you had the authority to act without Ken Paxton's, I don't know, authority in this document?
By this memo?
Yeah, by this
No.
memo. No, okay. So, can you tell us whether or not you felt that there was an ability to potentially save the state of Texas, the public of Texas, money by engaging in a mediation and potentially a settlement?
Well, I certainly thought that was the case. Otherwise, it wouldn't have been advisable to go to mediation.
Okay. Now, which specific plaintiffs in the whistleblower lawsuit were involved in the initial willingness to settle or request to settle the case?
Ryan Vassar, Mark Penley, and David Maxwell through their attorneys. I don't think we ever talked directly to them during this process.
What about Blake Brickman?
Well, as I said, Mr. Brickman's attorney told us, and actually the attorneys for the other 3 plaintiffs told us, Blake Brickman will not come to Austin. He will not participate in the mediation. He doesn't care. He wants his day in court.
Did you have a reason or idea as to why Mr. Brickman wanted his day in court?
Yeah, well, this is secondhand, so I understand Mr. Brickman is financially secure.
Objection hearsay. This is secondhand.
Sustained.
Your Honor, I'd actually argue that it goes towards settlement agreements in this case, and under 408B, it should come into play.
Then my objection is 408. This goes to settlement, and it's also hearsay.
Which is if 408B is the exception to the rule, and
We've had this discussion on, I think, yesterday or the day before, so I sustain the objection.
yes, Judge. Needless to say, Brickman's not there, is he?
Wasn't there, wasn't going to be there. Well, and I say wasn't there. we didn't anticipate this or plan this, but February 1st, the date we set for the mediation, ended up being the winter freeze.
Did Mr. Brickman's attorneys come to you with additional demand? Well, we'll get there. Talk to us about how the mediation went. What day do you recall you started mediation?
I believe it was a Wednesday, February 1st. And we had planned to be in Austin in person at the mediator, Patrick Keel's, former judge, office. As it happened, when the freeze set in, I stayed in Houston, and we were all on a Zoom.
And Mr. Dorfman, it's been a few years. Is it possible that the dates
might not have been a Wednesday?
Fair enough. Judge, may I approach Mr. Dorfman?
I think it was a Wednesday.
Was this a one-day mediation or a two-day mediation?
Ended up being initially planned to be one day, February 1st. We ended up, I think, on February 8th, having a second day by agreement with the plaintiff's attorneys.
Okay. Can you talk to us, and we'll get to the document in a second, but can you talk to us about how the first day mediation went?
It went long. I think we broke sometime around midnight. I want to give Patrick Keel all the credit in the world. We didn't know until it started turning dark that he didn't have power in his house. And at some point, he was on his laptop and lost that power, couldn't recharge, so he's now on his phone on the Zoom call.
This is all happening online, right?
All happening online till midnight, and I think his juice gave out at some point.
Was it a good day of mediation, or was it a bad day of mediation?
I didn't have a whole lot of expectations that this would settle. It didn't, obviously, on that first day, but we got real close. And again, we came in with the expectation that the option today is to settle with 3 plaintiffs. Sometime between 5 and 6 p.m., Mr. Brickman showed up, again, remotely, so I don't know if he was physically present.
Sure. I'm going to stop you real quick. Was this the first day that it got real close and Mr. Brickman showed up, or the second day of mediation?
First day.
All right. So you guys are making headway. You said Mr. Brickman showed up. Can you talk to us about any effect that only 3 of the 4 plaintiffs were present that it had on you? And then what happens when Mr. Brickman shows up?
Well, I think Mr. Hilton's memo, Exhibit 335, speaks of the fact that it's more valuable to us to settle the entire case.
Okay. And why is that?
Because if we're settling with 3 of them, we're paying money out. Mm-hmm. Yet we still have to pay our lawyers and outside counsel on top of that to go to trial, to go to discovery, all the expense, maybe less time, maybe less discovery because it's just 1 plaintiff, but still time, resources that we would like to save, ideally, by getting rid of the whole case at once.
Because what is the point of settling this case to you guys?
We have to be good stewards of the taxpayers' money, of the state fisc. And so we viewed this as any other case. One, that's why I argued for mediation, is we should at least try, if it's cheap and inexpensive to try and settle this and save that money and time and resources. And then settling with 3, I think it would be less valuable, but by the same token, we would offer less money. And I think Mr. Hilton says it in the reverse way in his memo that if Mr. Brickman would come to the table and we could make sure we don't have to expend any money after a settlement, I think his word is that would be worth a premium.
Okay. Talk to us about what happens when Brickman joins the negotiation table. How did that go down? Did you all reach out to Mr. Brickman, or did somebody else reach out to Mr. Brickman? What is your understanding?
I don't recall real clearly. I think it was a surprise to us.
And how did you take that surprise?
Good and bad.
Can you tell us about that?
The good is, look, we've all along preferred to settle with all 4 rather than piecemeal. It's more valuable, it's worth the premium for the reasons Mr. Hilton stated in the memo, the exhibit. So that was good. Bad is, wait a second, you told us all along, all week, maybe 2 weeks now, Blake Brickman's not interested in settlement, Blake Brickman's not going to participate in the mediation, he's not available, he's going to trial. And now now that we're talking real dollars and it looks good that we might actually settle, now he's interested. All that, was that posturing? Were we being sold a bill of goods? That the suspicion crossed my mind.
Did you all reach a settlement that night?
No, we got real close, but no.
Now, I want to talk to you about AG Exhibit 423. Do you recognize this document?
Mr. Asa, be sure you speak up and stay on that mic a little bit.
Yes, Judge. Do you recognize AG Exhibit 423?
Yes, I do.
What do you recognize that document to be?
This is General Paxton conferring on me and
Objection,
on...
Your Honor. Testifying from a document, not in evidence.
I'm going to lay the predicate right now, Judge, and I'll instruct the witness.
Overruled.
Without getting into the contents of the document, what do you recognize this document to be?
It's a memo from Attorney General Paxton to me and to Chris Hilton, subject line settlement authority dated February 8.
Okay. And did this email have an effect on your abilities and your thought process when going into the mediation on day 2?
It confirmed what we had discussed internally, yes.
Okay. Did it grant you any form of authority?
Yes.
All right. Is this email that you see in AG 423 a fair and accurate copy of the email that you received from Ken Paxton on February 8th of 2023?
Yes.
At this time, Judge, I would offer AG Exhibit 423 into evidence.
Any objection?
Yes, Your Honor, I have 3 objections. First, it was never produced. Second, it was listed on their privilege log, so it was never produced. And 3, it's hearsay, so it is inadmissible.
I can address the objections. I didn't hear your second objection. Could you repeat that?
Yes, this document was identified on your privilege log, so you never gave it to us. And now you're bringing it to court for the first time and showing it to us for the first time.
Let me address the privilege log first. As an attorney for Ken Paxton, I think at this time we'd be willing to waive any privilege.
I appreciate that, but the fact
I'm not done, and if I could just finish my response, then I'd be happy to be quiet and let opposing counsel go. So first and foremost, as Ken Paxton's attorney, I'll waive the privilege. With regard to hearsay, it's not offered for the truth of the matter asserted. It goes towards the effect on the listener in the mediation the next day. We heard Mr. Dorfman just state that on the record. And his first objection with regard to it being not being on the witness list, or excuse me, the exhibit list, Judge, this is a rebuttal case at this point, and arguably we don't even have to put a case on. Most of our exhibits are rebuttal exhibits, but we did give them a list. I am arguing that this is a rebuttal exhibit, and for that reason, it is not covered by the the exhibit list rule, and it should come into evidence.
Your Honor, may I respond?
Yes, you may.
Just so we're clear, the process that occurred was they produced a privilege log, never gave us this document, and now for the first time they are sandbagging us with this document without giving it to us. As the court is aware, you have ruled several times that documents that we did not produce would not come into evidence. They never gave this document to us. This is the first time we're ever seeing it. If they want to take every document off their privilege log and put it into the record, we're good with it. Otherwise, we have a valid objection. Second, Your Honor, it is clear hearsay. There is no business record. The predicate laid was not the standard for hearsay, and so it is inadmissible on all of those grounds.
If I, and just brief, yes, Judge. Well,
Go ahead, Mr.
I'm not aware of a privilege log that we came up with or provided to the House Board of Managers first and foremost. This was on our 4th supplemental notice of the exhibit list. I think the court is aware that the managers have given us plenty of exhibits
You're not aware
throughout the
of a
course of this
privilege
trial.
log?
I mean, if I remember correctly, Mr. Bangert dumped phone exhibit text messages between him and the Attorney General during the middle of trial. So to say that I'm sandbagging them is just simply not an accurate reflection of what's going on throughout this case or with regard to this exhibit.
Okay. I've heard both arguments. Give us a moment.
Maybe I'll try to drive it. I'll do like 6 hours Friday evening, get halfway, do 6 hours the next day, find some sort of offensive, some sort of hotel there, and maybe try to one-shot it the next day or something back or something. Yeah. Matthew, offensive use doctrine, can't withhold it and then try to use it now. Yeah, like, yeah. Yeah. I've never heard it called offensive use doctrine, but that's cool. Is the AG winning or losing? In my estimation, I think they're losing. They're not going to call the first AG. They're just not going to do it. I know they're not going to do it. Surely they would have done it by now. We're not going to hear from the first AG. All we heard was from Mr. Hearsay. Matt, were you here for Mr. Hearsay? It was the most bullshit witness I've ever seen in my life. This guy in HR, it's like, oh, here's a whole bunch of things I was told by other people about how these employees were really bad employees. I took these statements completely at face value and did no investigation whatsoever on my own based on these statements that other people provided me. I thought the terminations were totally cool. We're not offering for the truth of the matter asserted. Bullshit. You totally are. You're totally trying to get it in for the truth of the matter asserted. Bullshit. It's not being offered for the truth. And it goes to the effect on the listener, why he wrote the opinions he did. Bullshit. You're offering it for the truth. This guy has no personal knowledge of anything. He just takes anything that's come in. So he's like, yeah, that's what people said to me. Here's what, that they're bad employees. They're really, really bad, and therefore they're justified in being fired. This guy doesn't know anything, Matt. It offended me. It offended me. It offended me to the point that I was like, if this guy was a witness in my courtroom, I'm yeeting him out. Personally, sua sponte. I'm removing the witness, striking his testimony, and giving harsh words to counsel for submitting him in the first place. It's Mr. Hearsay. It's hearsay embodied in a person, Matt. It pissed me off. Yes, I think the AG is losing. I think the evidence against him on the whistleblower retaliation claim is really good, and Mr. Hearsay, not to the contrary. Well, I've completely ignored Mr. Hearsay because I can. I don't find him to be a credible witness. Anything he says sounds like lies, and he doesn't know anything anyway. So I've used my prerogative as hypothetical juror to ignore this witness, which is in my prerogative. So yeah, I think he's losing.
Jurors, please take your seat. After consultation with my team here, we will sustain the objection on hearsay. Continue.
Yes, Your Honor. Did General Paxton delegate you the authority to engage in a settlement agreement with the whistleblowers?
Yes.
Okay. Did he do so on February 8th of 2023?
On or about that date.
Where was Ken Paxton while the settlement agreement was going on?
I don't recall. I know he wasn't in Austin, and I believe he was traveling, which is in part why we needed to formalize my authority and the scope in case we weren't able to reach him on short notice if it appeared that we had an agreement subject again to his confirmation.
But to be clear, you guys formalized that delegation of duty, right?
Yes.
Right. So then you go into the second day of mediation, right?
Yes.
Will you talk to us about the second day of mediation?
I believe it was also remote by Zoom, even though the weather had cleared up. And I can't remember exactly when it was we agreed we had a deal, but the same dynamic had played out. Mr. Brickman was participating from the start on the second day at least, and so we were now dealing with 4 plaintiffs rather than a settlement for 3, as we had most of the first day of mediation.
And did you all reach a settlement agreement?
We did.
What was the settlement agreement that you all came to?
And to be certain, I think we reached it that day. It may have been the next morning.
Okay.
Before it was finalized.
Fair enough. What was the settlement agreement?
It was in the form of a mediated settlement agreement, payment of $3.3 million to the 4 plaintiffs in exchange for full and complete releases of liability against the Office of the Attorney General. There was other components. We had agreed to, and if you have the copy of it, that might help me, but we had agreed to attempt with ERS to reinstate Mr. Vassar in his retirement plan. I think that was the only fringe benefit that was addressed, but I recall that. And then Mr. Maxwell had a separate F5 administrative hearing case in SOA, State Office of Administrative Hearings, which was abated pending the pendency of the whistleblower case. So that stayed, their filing stayed that proceeding, which was an attempt to reclassify him from a plain discharge to an honorable discharge, without which his employment as according to them, as a law enforcement officer in Texas was problematic.
Okay. How did you feel about this agreement on behalf of the Office of Attorney General and the public of Texas?
I felt overall, especially now that it was a settlement of all 4 plaintiffs and the case would not go forward, it was a good assessment of our risk. To be honest, it's more than we would have liked to have settled for. I'm sure it's it certainly was less than the plaintiffs' lawyers were telling us they should settle for. So that's probably, again, 95% of mediation settlements fall into that category.
Okay. Now, after this case comes to an agreement, you still have this petition for review in the Supreme Court, right?
It's still pending, yes.
And did you all file any motions with the plaintiff's attorneys in regard to that petition for review?
I think the next day.
Can you tell us what motion you filed with the plaintiff's attorneys in regard to that petition for review?
I believe it was styled as a joint motion to abate in the Supreme Court.
Can you tell us what the joint motion to abate did in this case?
Very short motion. It was simply telling the court, look, we've reached a settlement agreement that's binding and disposes of the case. If the Supreme Court went ahead and conferred and spent time deciding whether to take our case or not and made a decision, they'd be very peeved if they found out later that that was wasted energy on their part. So we didn't want to upset the court. So we let them know, hey, we've reached a settlement. We're going to paper it up and finalize a larger document. It's all the bells and whistles, dots and I's,
Eric
cross and
asks
T's.
about someone being impeached from the Senate or House.
You don't
That's
need
not
to
possible.
do anything now, and the parties are jointly
the
asking
House
you
and Senate,
to
respectively, have the
put it
ability
aside
to
for now.
expel a member.
Now, I want you to focus your
They wouldn't
attention
be
on
impeached, they'd
the
be
article of
expelled
impeachment
by
that is
their
on the
respective
screen right now.
houses.
And it states, the settlement agreement stayed the wrongful termination
That was true
suit
in the
and
United States
conspicuously
system.
delayed the
They tried
discovery of
once.
facts. Is that true?
No.
I think
Why
the
is that
House
not true?
tried once
Well,
to
the plea of
impeach
jurisdiction
a member of
stayed
the
the
US
termination
Senate, and the
suit
court was
pending
like, no.
the Supreme Court. At that point, the Supreme Court's consideration. It didn't, whether it's conspicuous or not, it didn't delay the discovery of facts by settling. There was no discovery ongoing at that time. And the way this is written, it's sort of passive voice. But who's doing the delaying? Is the suggestion here that the whistleblowers, by filing a motion to abate with the Supreme Court, are trying to delay the discovery of facts?
Mr. Dorfman, I don't know. I didn't draft the articles of impeachment. Okay, so I want to move on to who pays this lawsuit. Who pays this lawsuit? Who pays the settlement?
Well, the defendant is the Office of Attorney General. That's the party that would be liable and would pay any settlement. Obviously, the legislature has to fund that. So those
And why is that? Why does the legislature have to fund that settlement?
goes back to our discussion about sovereign immunity. You can't sue the state without its consent. And even if you have a waiver of sovereign immunity, like the Texas Tort Claims Act or the Whistleblower Act, and you go get a judgment from a court, jury, verdict, all the way, hold it up to appeal, you have a final, unappealable judgment that entitles you to, let's say, $2 million against any state entity. This legislature, this body, can still decline to pay it. They have to agree.
Okay. And are you aware of whether that lawsuit has been paid?
No, it has not been paid, not been funded.
Now, did you engage, without getting into specific conversations of what was said, did you engage in discussions with the plaintiff's attorneys about getting the legislature to pay for this lawsuit?
Yes.
Were they for or against that?
For it. Excuse me, for it.
Now, were you a part of any specific discussions with any legislators about getting this lawsuit funded?
Yes, I was.
Can you talk to us, without getting into the specific conversations you had, can you talk to us about who it was that you met with to talk about the settlement?
I think there were two separate meetings that I participated in. Other people in our office had more, both on the House side and the Senate side. I recall a meeting with Senator Hughes where we discussed it, and with Senator Huffman.
And so you also mentioned that other people were meeting, or were other people meeting with other legislators about getting the settlement paid?
I believe our head of government relations,
Expedia,
at the
let me
time,
take a
Ryan
look to see
Fisher,
what
and
Expedia
his
means,
deputy
flying
Colleen
Frontier.
Tran were having such meetings, formal or informal. And Mr. Hilton, I think, too, had some
And
meetings.
if you know, were the plaintiff's attorneys in this case aware of these conversations happening with legislators?
Absolutely. They were adamant. There's email traffic where they're saying we're not doing enough. We need to do more. This person wants to meet with you. That person wants to meet with you. And we said we're doing our best. We agree. We have an obligation to act in good faith and make reasonable efforts. But it's really, you should be highly motivated to do what you can and have the meetings you need to have as well. And we'll show up with you, but let us know.
I don't have it for
And
that
just
cheap.
because they haven't agreed to pay it yet doesn't mean they can't at a later date, right?
Of course.
Do you, and you still believe that it is the state of Texas, the public funds, that should fund this settlement agreement, right?
I believe that initially. I believe it now if the case goes back to trial, which I think it's settled, but others may feel differently. All the reasons that were there before, again, we'll go back to the Supreme Court presumably, so, but the risk return of time, the certainty of time, litigation, resources, lawyers being devoted to this when they could be doing Biden administration lawsuits or something.
Let me stop you real quick. And just to be clear, you said if the case went back to trial. If the case had gone to trial and there was a judgment entered against the Office of Attorney General, would it still be, should that still be paid from public funds?
That would be up to the legislature to decide.
Okay.
No one can make them.
Would Ken Paxton ever be personally liable for that lawsuit?
No, he's not a defendant.
Okay. You were at the Office of Attorney General. You're currently still working there, right?
Yes.
My understanding is you took leave for a little bit of time.
Yes.
Okay. About how long were you gone from the office?
From roughly early May, I returned to work remotely probably around the July 4th holiday.
So just recently, right?
Just recently.
Okay. I want to talk to you about the time period from when you started at the Office of Attorney General in December of 2020 up until you took leave in May of 2023, okay?
Okay.
Can you talk to us about some of the accomplishments made by the Attorney General's office under the leadership of Ken Paxton while you were there?
Well, I've referenced the Google ad tech lawsuit, one of the biggest antitrust cases, not just in the country, but in decades. That's still ongoing. And,
Objection. I apologize for interrupting. Anything after this lawsuit is irrelevant.
Actually, Judge, if I may be heard on the matter. Yesterday, the House Board of Managers elicited testimony from Blake Brickman. I have the transcript here and be happy to show the court, but they've opened the door to the Office of Attorney General's productivity after this whistleblower lawsuit, after these terminations occurred. They talked about the fact that there was not productivity and that the office wasn't functioning well. As a result, they've opened the door. That would leave a misimpression on the jury, and as a result, Mr. Dorfman should be able to talk about how the office is functioning.
Overruled.
So you talked to us about one of the lawsuits. Would you please continue to talk about the other accomplishments and the functioning of the Office of Attorney General?
I should have started with our immigration cases, which I'm probably most proud of.
Would you please tell us about your immigration cases?
Day one, I mentioned this maybe earlier, of the Biden administration, all the executive orders that came out. One was the 100-day moratorium. We were the first to get a nationwide injunction requiring the Biden administration to abide by congressional directive that no, if you have a deportable alien, they must be deported within 90 days, no exceptions. And that we continue to file and challenge and try to hold the Biden administration to the letter of the law and the rule of law on our border. Title 42 is one of those cases. DACA is a continuation of a case then Attorney General Abbott brought years ago against the Obama administration. We just won, I think, in the last week, a ruling out of the federal court in Houston that the revised Biden administration DACA policy is just as illegal, unlawful, I should say, as
we do many good things at the Attorney General's office. We do many important things at the Attorney General's office.
About the Google case?
Fighting the good fight.
That's one of the Google cases. Another Google case we settled before I took leave.
Irrelevant.
We broke away from a multi-state, all the states suing in one location. We broke out of that, filed our own lawsuit in Texas state court. We settled with Google for $8 million when all the other states put together settled for $9 million over the Google Pixel phones, and that was to the relief of Texas consumers who were deceived by misleading advertisements.
Any litigation with regard to opioids?
This is mostly before my time. The money has come in since I've been at the agency, but I can't claim credit. General Paxton himself led the nationwide negotiations on that, worked very hard on that, deserves the credit for that. And it's been billions in money from those manufacturers, distributors, marketers, consultants, pharmacies that were responsible for the opioid crisis.
You told me why it's relevant. I must have missed it then.
And so based on what you've seen at the office during your time there, have they been successful in their efforts and their litigation under the leadership of Attorney General Ken Paxton?
I think so. I've been amazed at what we've accomplished. We've worked our lawyers very hard, and they've done very well. They deserve the credit. They're the ones going to court, making the winning arguments and filing the winning briefs, not me. So I don't want to seem like I'm tooting my own horn when I say CNN, no great fan of Attorney General Paxton or our office, had to concede in a news article that Texas had become the legal graveyard for Biden administration policies and executive orders.
Well, thank you, Mr. Dorfman. I'll pass the witness, Your Honor.
Your
was
witness?
wasting my time.
That sound you're hearing you have not heard for a long time. It's called rain.
We're sure. All right. Hi, Mr. Dorfman. How are you?
I'm very good, thank you.
I was.
The mic's not on, Mr.
Can you hear me?
Yes, sir.
Mr. Dorfman, we were looking at Exhibit 335 that was introduced by your counsel, or counsel for Mr. Paxton. Can you pull that up for me, Stacy? No.
Check your mic one more time. It doesn't sound right.
Is it not working?
No, it is now, but you're tall enough that you're going to have to bend down a little bit.
Yes, Mr. President. Is this the memo that you were talking about on 335 with the counsel a moment ago?
It's one of them, yes.
And this memo was created by Chris Hilton?
I believe so, yes.
And one of the lawyers standing over there, sitting over there?
Sitting, yes.
Sitting, yes. When you got this memo, were you shocked?
By what?
By the fact that Mr. Hilton was attempting to usurp the power of Ken Paxton by removing his name from the letterhead.
No.
Did it appall you?
No.
Was it simply a matter of Mr. Hilton picking out this letterhead that is available to every employee of the AG's office?
I think you'd have to ask Mr. Hilton about that. I don't know.
You talked about the internal investigation that was conducted by the Attorney General's office, correct?
Yes.
And you talked about the fact that it needed to be fair.
Yes.
It needed to be unbiased.
Well, it needed to be objective, I think is the word I used.
And the subject of that investigation was Ken Paxton.
One of the subjects of that investigation.
It certainly was a big part of it, right?
The allegations against him were a big part of it.
Your Honor, may I approach the witness?
Thank you.
Mr. Dorfman, I am showing you what has been marked as 524, Exhibit 524. Do you recognize this document?
Give me 1 minute to read it quickly. Can you restate your question, please?
Yes, maybe I can make it easier. You see your email address right there, halfway down the page?
I do.
This is an email exchange that you received, you were on,
Yes.
and so as a result, you recognize this document.
Yes.
And, to use a predicate that's being laid by your counsel, this fairly and accurately represents the email as well as the attachment.
I think that's right.
Your Honor, at this time, we offer Exhibit 524.
Any objection?
Yes, Judge, I'd object to hearsay, and they haven't provided a proper foundation for this witness to sponsor this document.
Your Honor, we have a business record affidavit that overcomes hearsay. That gets by that, and the predicate is this witness was part of this email exchange, is a proper sponsoring witness, testified it fairly and accurately represents the email exchange that he was a part of.
Judge, I'm just confused. I don't have a copy of a business record affidavit.
You do have a copy of the business record affidavit. I didn't hand it to you, but if you want, I can get it for you.
Well, that'd be great. I think part of the rule is that it's, got to be provided to counsel, so that would be good.
I will.
Would you provide him a copy?
Yes.
Judge, if I could just have a moment to look at the business record affidavit.
Take a moment.
Thank you.
Your Honor, I assume we're stopping the clock,
Yeah.
respectfully.
Judge, I mean, I don't see why it should. They're offering it.
If it's a minute, we're not stopping the clock, but if it's longer than that, I'll stop it.
Judge, I have to reurge my objection. This business record affidavit is not the correct affidavit for these documents. It references Office of Attorney General numbers that are just not contained on the documents that counsel has provided me. And so I can't verify that it's the document that he's purporting it to be.
And we don't have a copy either of the business affidavit.
I can get you a copy.
That would be good. Yeah, it's supposed to be attached so that we know.
I appreciate that, Your Honor. It was attached to a bigger swath of documents. This is just one of the documents that's part of it.
This is all in response to which is it Article 10 that they've been arguing about for like the last hour or something. Article 8 for the settlement agreement. I mean, I didn't think it was particularly strong before. I didn't think it was particularly strong in the state's case anyway, or the House's case anyway.
We will stop the clock and give you credit for a couple of minutes here.
Because it wasn't the settlement agreement that delayed the discovery of the facts. So I think it's legally deficient. So, like, for me, this is, I mean, yeah. So for me, it doesn't do anything because I was already on Paxton's side on this article. Article 10 is constitutional bribery. That's the renovation of the home. That's a Paxton win, too. That's a Paxton win, too. So where we are sitting right now, Article 1, Paxton loss. Article 2, Paxton win. Article 3, Paxton win. Article 4, Paxton win. Article 5, Paxton loss. Article 6, Paxton loss. Article 7.
Mr. Dutko, I will say I stopped the clock, but
Paxton win. Article
either
8,
side has
Paxton
not been
win.
ready to
Article
present us
9,
what is
Paxton
needed. We have
win.
not stopped the clock
Article 10,
previously,
Paxton
so
win.
I've given you 2 minutes here, but I don't know how long you're going to take.
Yes, Your Honor.
It does not seem you have your paperwork together.
Yes.
So
Article
can we continue to
16,
get the clock running? And come back to
Paxton
that if you'd like?
loss.
Yes.
Article 17,
Resume the clock.
Paxton loss.
Resume your questioning.
And Articles 18, 19, and 20
proceed.
come along for the ride, and any
Mr.
convictions.
Dorfman,
So
when you were on direct examination, you spent a lot of time talking about the fact that the quality of attorney that is currently at the Attorney General's office. You remember that?
Yeah, I think so.
And you said how you were proud to walk through the halls and the lawyers and the high caliber of lawyers.
I don't recall saying that. It's certainly true, but I
Right.
don't recall saying it.
And you were talking about how good the lawyers are and how hard they work. Do you remember that?
Yes.
Yet, despite the fact that there's the high quality of lawyers that currently exists at the Attorney General's office, Ken Paxton had to hire Louis Brisboe as outside counsel.
Didn't have to, he did.
And it was certainly something that could have been handled internally.
I'm not going to agree with you on that. Now, I have an explanation why.
Are you aware of the fact that Louis Brisboe has billed the Texas taxpayers $524,000 for the work that was done?
Yes, I am.
And that doesn't bother you?
I think I've been very clear that I view the Texas fisc as a sacred calling for us. That's very important for us to preserve it and spend it wisely. Again, I had a reason why I supported the hiring of Louis Brisboe as outside counsel, but part of the motivation for settlement was to stop paying Louis Brisboe as outside counsel.
Your Honor, we have the business record affidavit that we were going to present to opposing counsel.
Okay.
Is this for this document? You just got extra copies of VRAs on. Again, Judge, I got to re-urge the objection. The document that they've handed me doesn't have a single Bates label on it, and this business record affidavit talks about Bates label documents. No way for me to verify the validity of these documents.
Your Honor, just so we're clear, these are documents that
Could I have a copy of that?
Yes.
And before you answer his objection, let us look at this.
it'll be very interesting when it comes down to it to see how the Senate votes on these things. It'll be also interesting to see if any of the Democrats vote against any of them. Even though some of them I think are completely legally void. But it'll be interesting to see if some of the Democrats vote against some of them or not. Politics is not law, that's for sure. All or none? That's a quite reasonable conclusion. In the end, I think that's quite reasonable.
We're ready to resume. I'm going to sustain the objection because we don't find a way to identify this affidavit with the document.
Yes, Your Honor. Remember when you talked about the plea to the jurisdiction a little while ago?
Yes.
One thing is clear, a plea to the jurisdiction stays the case.
Once it's denied or granted.
Right, and so when you filed that plea to the jurisdiction, you, as the Attorney General's office, knew that the case would be stayed.
Yes.
That meant there would be no written discovery.
Yes.
That meant there would be no deposition discovery.
Right.
That means that Ken Paxton did not have to testify under oath for the entire time that that plea to the jurisdiction was being determined.
No one had to testify, yes.
Right, but Ken
Or not
Paxton
to.
didn't as well,
Yes.
right?
Yes.
And so when you filed it, you knew that was going to happen.
Once a ruling was made, yes.
Right. And even though you lost at the trial court, instead of going back to the case and conducting discovery, you appealed it to the Court of Appeals.
Well, we didn't lose the case at the trial court. We lost the plea.
Right. You lost the plea to the jurisdiction.
We disagreed with that and we appealed it, yes.
Which means that when you lost that case, that plea to the jurisdiction, that meant if you did not appeal it, you could go back to the trial court and take discovery.
If we chose not to appeal it,
Right.
I suppose that's true.
And then you appealed it
We did.
and lost.
We lost in the third court.
So then, instead of going back to the trial court to conduct discovery, where Mr. Paxton would have to give his deposition, you took a flyer and took it to the Supreme Court.
I disagree with you that we took a flyer. We urged the constitutional separation of powers, which is a pretty important constitutional doctrine, and we also relied on the sovereign immunity of the state, which this body thinks pretty importantly of as well.
Right, and then while the case was pending at the Supreme Court, there was an appeal, election, right?
Yes.
And after the election, before the Supreme Court, where you said you had a good faith basis to go, immediately after that's when you guys settled, right?
Not immediately, no.
Shortly thereafter.
We settled 3 months later, a little more than 3 months later.
Your Honor, I was told that the document that was printed for everybody had the Bates label that ran off the bottom, and so now I have a version that has the Bates label that identifies it as a document within the range on the Attorney General's, on the business record affidavit. Since it was a short notice, I have one copy. I would like to show it to opposing counsel and then bring it to the court, if that is okay.
Can I see it first?
Yes, Your Honor.
I render no opinion as to what the right thing to do here politically is, of course. I suppose you could think that, because it is ultimately a political question, because it's, political. You could believe Ken Paxton did all these things and still believe that he should remain in office. Because you think on balance, whatever flaws he has is outweighed by the benefits that he provides. How are my parents doing? They're doing fine. Thank you for asking.
You can come forward if you'd like. Come forward if you like.
What's my take on Rusty cutting 2 hours off his time?
Y'all can take a stand-up break, but don't leave because we're moving forward.
I don't understand the question. What's my take on Rusty cutting 2 hours off his time? I don't understand the question. You don't have to super chat again. Could you clarify the question? What do you mean Rusty cutting 2 hours off his time? You don't have to super chat again, but I don't understand the question. If Paxton's convicted, yes, he can run for federal office. Yesterday when he closed, he had 2 hours left. That's 2 hours in his total time. That includes all the time he needs for cross. So, yeah. You of course he left time on the clock. He needs it for cross. So, yeah, it's 24 hours for all your witnesses and all your cross. So, if anything, he probably should have left more time on the table, to be honest. Not a lot of buffer. Rusty did waste a lot of time. He wasted at least 20% of his time. He wasted at least 4 hours of time. Check Expedia. These trials take a lot of energy out of you, man. These long trials, they take so much time. It takes so much energy out of you. One third is plausible but weak. One third is created, hyped up, partisan hacketry. One third completely irrelevant. I don't know about that, but...
Members, please take your seats. Give them a second to settle down here for a moment. You may continue.
Mr. Dorfman, I'm going to make this short because everyone's ready to be done. You started in December of 2020.
That's a yes.
And when you started, all of the whistleblowers had already been fired or resigned, correct?
Yes.
You didn't interview Mr. Vassar.
No, I did not.
You didn't interview Mr. Bangert.
No.
You didn't determine the veracity of what their testimony is in front of this Senate.
I haven't been allowed to watch their testimony, so I don't know.
Right, but you didn't determine the truthfulness of what they were saying.
To the Senate?
No, as far as the whistleblowing allegations.
We took their pleadings at face value and addressed those in the report.
I appreciate that, but you didn't make a determination yourself.
I never interviewed them, but the report is I don't know if you call it a determination. It's a report of our office.
Right, but when it comes to determining personal knowledge about the allegations that are made here in the Senate,
Yeah.
the allegations that are made before you got there, your testimony would not be helpful as far as personal knowledge goes.
I have no personal knowledge of what happened. I didn't hear any conversations in September or October or prior to that at the agency. That's true.
Pass the witness, Your Honor.
No redirect, Your Honor.
Witness does look a little bit
Can we
like
excuse
Mike
the
Lee.
witness, both sides? We
Yes,
good?
Judge.
Thank you, Judge.
He does look a little bit like Mike Lee.
Mr. Busby, who is the next witness?
Your Honor, Attorney General Ken Paxton, res.
Okay. Well, then. All right. Well, that'll bring us to the end of that then, I guess. Well, okay. So, well, you've heard all the testimony in the case before you, so, yeah. Okay then. We're not going to hear from the first AG who has all the information. So, yeah. So, based on the fact that we have all the information, we can give a final summary because all the evidence is admitted. So what is our final determination? I guess we can reach a final adjudication on the counts. Not guilty. You don't want to look over the counts? Well, that's easy. I was going to pull it up and actually go through them one by one, but if you don't want to do that. Rose says not guilty. Okay, well, I was going to pull them up and go through them one at a time, but all right, fair enough. I guess the conclusion is not guilty and we don't need to do that. Some days I don't know why I'm here.
The parties approach the bench.
My own mods don't want to hear my summary. It's a waste of my time. I swear to fucking God, Mark. In the name of all that's holy. Are you trolling me? Are you trying to piss me off? I swear in the name of God. Cosmos says, don't bring God into this trolling attempt. I'll do whatever I want. It's my channel. Fuck you. Let me fix the margins on this. For whatever value it has. We will do this. All right. We're going to try to approach this from a legal perspective, bearing in mind that the question is proof beyond a reasonable doubt, which I always like to think of that as, do I have doubts that are based on reason? Because that's what reasonable doubts are. They're doubts based on reasons. They're doubts that are articulable based on the facts that are available, right? It's not speculation. It's not wishes. It's not beyond all doubt. It's reasonable doubt. Doubts based on reason. Can I articulate a reason to doubt it or not? That is how I'm going to approach it, based on the evidence presented that we've heard. So that's how I'm going to approach this. Article 1. Disregard of official duty, protection of a charitable organization. He violated his duties of office by failing to act as public protector of a charitable organization. Specifically, Paxton caused employees of his office to intervene in a lawsuit brought by Roy F. and Joanne Colmity Foundation against several corporate entities controlled by Nate Paul. Paxton harmed the Mitty Foundation in an effort to benefit Paul. Guilty. The evidence represents that his agents and employees intervened in this lawsuit and put pressure on them to settle this, that Nate Paul was a real estate investor that the Mitty Foundation had invested with as part of its charitable funding in order to get money. They invested in a real estate deal to further their charitable interests in order to use the money that would be obtained from that property deal to further their charity. The evidence represents that Nate Paul had a profound interest in that. The deal went south. The evidence represents that Paxton caused his employees and agents to intervene in the lawsuit by directing them to put pressure on the foundation in an effort that would have benefited Paul to the tunes of millions of dollars, and that there was no interest for Texas in the intervention of the lawsuit. It was a dispute between a charity and a landlord developer. It had no particular interest in Texas. There was no reason for the Attorney General to get involved. It did for the personal benefit of Nate Paul. So as to count one, I would vote guilty. As to count two, with respect to holding the legal misuse of official power to issue legal opinions under subchapter C, chapter 402, Government Code, not guilty. The evidence reflects that the opinion was not issued under subchapter C, chapter 402 of the Government Code. The opinion on its face says it's not, and also it doesn't meet the statutory elements to have been a legal opinion under that Government Code. So it is not guilty as a matter of law. Article 3. Disregard of official duties, abuse of open records process. Misuses official power to administer the public information law. Paxton directed employees of his office to act contrary to law by refusing to render a proper decision relating to public information requests for records held by a Department of Public Safety and issuing a decision involving another public information request that was contrary to law. Not guilty. Although the information reflects that Paxton directed his employees to act abnormally in the no opinion letter, it was an action that ultimately is of no consequence, and the motivations for doing so are somewhat unclear on the record. So I would vote not guilty. As to count 4, misuse of official information. Paxton misuses official powers to administer the public information law by improperly obtaining access to information held by his office that had not been publicly disclosed for the purpose of providing the information. Not guilty. The record reflects that Nate Paul had independent access to the information and could have obtained the information through other means. So because the Attorney General is not the only means by which he could have obtained the information, and there's no direct evidence that the Attorney General provided it, the charge is there is doubts based on reason. So as to count 4, I'd vote not guilty. As to count 5, for engagement of Kamek, Paxton engaged Brian Kamek, a licensed attorney, to conduct an investigation into a baseless complaint during which Kamek issued more than 30 grand jury subpoenas in an effort to benefit Nate Paul or Nate Paul's business entities. I vote guilty. The record reflects that Paxton personally engaged Brian Kamek. He personally signed the contract. Brian Kamek was his direct report. He personally engaged the guy. They had conversations. He was the one that was directly reporting to the Attorney General. The record also reflects that Nate Paul's attorney was providing information to Brandon Kamek, that the Attorney General was being provided that information, and that information extended to who to contact at the District Attorney's office to get certain subpoenas issued, and that those issues and who to subpoena and those people to be subpoenaed were personal enemies of Nate Paul. So it was Nate Paul via his attorney that was directing who to serve the subpoenas on for the direct interest of Nate Paul. So I would vote guilty on Article 5. As to Article 6, Paxton violated his duties by terminating and taking adverse personal action against the employees of his office. Specifically, Paxton terminated the employees of his office who made good faith reports of unlawful action to law enforcement authorities. Paxton terminated employees without good cause or due process and in retaliation for reporting illegal acts and improper conduct. Paxton engaged in public and private campaign to impugn the employees' public reputations or prejudice their future employment. I would vote guilty. The record reflects that all these employees were fired within 30 days. There is a presumption provided by law that to do so means it was retaliation. Some of them were put on administrative leave literally the day after he told Paxton about it. That they told Paxton about it and were immediately the next day put on administrative leave. It can't be due to anything else. There's simply not any doubt based on reason that the actions Paxton took were because they are whistleblowers. There's simply nothing else that makes any sense in the timeline based on the actions that were taken. So I would vote guilty. Article 7, misapplication of public resources. Paxton directed employees of his office to conduct a sham investigation into a whistleblower complaint made by employees who Paxton terminated and create and publish a lengthy report containing false or misleading statements. Not guilty. There was a legitimate reason to have the investigation, and there's insufficient evidence that the people that did it were creating false or misleading statements. They were obviously trying to make the best possible case for their client, but that is decidedly not the same thing as a false or misleading statement. There is no evidence that the people who generated the report were directed to or did do false statements. They simply tried as best they could to interpret the facts in the way most colorable to Paxton, which is decidedly not the same thing. So for those reasons, I would vote not guilty.
You can still stand. I just need a little quiet. Both parties come back.
Righteous Wing says, unless you buy the defense's argument, they didn't fill their proper recording requirements. They did. I think it's a bullshit argument. So, yeah. They meet every element of the whistleblower statute, by my opinion. Article 8, settlement agreement. Paxton entered into a settlement agreement with whistleblowers that provides for settlement of public funds. The settlement agreement stayed the wrongful termination suit. Not guilty for that reason. The settlement agreement is not what stayed the termination suit. What stayed the termination suit was the filing of the jurisdiction-based argument. So it is deficient as a matter of law, so not guilty. Article 9, Paxton benefited from Nate Paul's employment of a woman who is having extramarital affair. Not guilty. There is literally zero evidence in the record of this article. It is completely insufficient. This should be dismissed by the court if we were in a courtroom. There is no evidence to support this charge legally. It should be dismissed by the court. It shouldn't even be sent to the jury. But, not guilty because there's no evidence for it. Article 10, Paxton benefited from Nate Paul's providing renovations to Paxton's home. Not guilty. The evidence about Nate Paul providing anything with respect to the home is woefully insufficient. There is some mention of Nate Paul's name in relation to things, but nothing that says that Nate Paul provided the renovations. So it is completely unsupported. So Article 10 is not guilty. Articles 11, 12, 13, and 14 have been held in abeyance, so I will not pass an opinion at this time. Article 15, false statements in the official record. Paxton made or caused to be made multiple false or misleading statements in a lengthy written report issued by his office in response to whistleblower allegations. Not guilty. Again, for similar reasons. They were trying to make the best possible case they could from their perspective. At least the people did, and there's insufficient evidence of Paxton's direct involvement in the creation of the report, so he didn't make or cause to be made because Paxton's direction here with respect to this is unclear. So I would vote not guilty. Article 6, conspiracy. While holding office as Attorney General, Kenneth Paxton acted with others to conspire or attempt to conspire to commit acts described in one or more articles. Guilty. Conspiracy, of course, can be proven by the acts of the people. Words are ideal, of course, to show the agreement, but agreements don't necessarily need to be proven by words. The fact that they're acting in concert provides a reasonable basis to provide an inference to a juror that the basis of it is the agreement, the fact that they're all acting in concert, and the fact that Nate Paul and his attorney and Paxton are doing these things, and Paxton and Nate Paul's there behind everything. The idea that there's an agreement is sort of shown, at least to my satisfaction, beyond a reasonable doubt, because I don't think there's a doubt based on reason. There's no other basis to conclude why. There's no other reasonable basis to conclude why Nate Paul's name is constantly at the back of this thing. So the conspiracy I tend to credit. Misapplication of resources. Kenneth Paxton misuses official power by causing employees of his office to perform services for the benefit of others. Guilty. Again, this is just because it's basically almost derivative, because he was using his office for the benefit of Nate Paul, qua Nate Paul. That's a misapplication of public resources. Dereliction of duty. While holding office, he violated the Constitution, his oath of office, statute, and public policy against public officials acting contrary to the public interest by engaging in the acts. Almost guilty by force, because it almost necessarily comes along for the ride. Unfitness for office. While holding office as Attorney General, Paxton engaged in misconduct, private or public, of character as intended for unfitness office as shown by the acts. Guilty, kind of comes along for the ride. And Article 20, abuse of trust. Misused, or failed to use official powers in a manner calculated to subvert lawful operation of government in the state of Texas and obstruct fair and impartial administration, thereby bringing the Attorney General's office to scandal and disrepute. I would vote guilty. So, that is my assessment of the charges. And my humble opinion, based on my best interpretation of the facts and the law, as we are sort of there. So, yeah. That is what, and I still think by far and away, the best one is the Article 6 for the termination of the whistleblowers. They didn't even really try to argue against it. All they had was Mr. Hearsay. And Mr. Hearsay has nothing of value to offer on this subject. Oh, I was told that they were incorrigible. I was told a whole bunch of things. Mr. Hearsay has no evidence to offer this court, and I refuse to credit him. Also, he's slimy and I don't trust him. So, using my prerogative as a juror, I choose to not believe him and give him no weight, which I can, because I'm assessing his credibility, which I find to be 0. So, that's where we sit. And that's where we sit, in my humble opinion. You can't vote for 19 without coming along for you can't vote for 19 independently, because 19 says it's unfitness for office as shown by the acts described in one or more articles. So you have to find liability somewhere else to vote for 19. You can't vote for 19 independently. And 19 almost necessarily comes along for the ride. So it's almost not worth mentioning because it's pointless. Like, you can't vote for 19 independently, and if any other article's true, it's like necessarily proven. So it's like, it's pointless. So the HR guy did not have any documentation. No, HR guy was pointless. HR guy's entire testimony was, well, we have policies at the office that, prevent people from acting, insubordinately and using a sharp tone. And I was told this, and I was told this, and I was told this. I did 0 independent investigation of anything. I was just told this. And based on this, I wrote a memo that says, yeah, fire the guy. HR guy is pointless. HR guy has nothing to offer us. He has no value. He has no value. He's not a witness. He didn't see anything. He didn't hear anything. He didn't observe anything. He's pointless. HR guy is not a witness. It's some bullshit. So that's where we're sitting. We don't know his motivations. That we don't know. We don't know what Paxton's motivations are, which is also slightly unsatisfying. We don't know why Paxton did it. But of course, motive isn't necessarily an element of the overall thing. Unproven is not a thing in the United States legal system. That's not a thing. That might be a thing in some systems of government, but unproven is not a thing. I don't know why you keep saying unproven. That's not a thing in the United States system. So I only have about 5 more minutes of streaming anyway, so I guess we're ending at a good time because there's nothing more to talk about, but we'll see if they wrap this up, and we're going to end the stream pretty soon. Jay War says he claimed he was concerned with the improper FBI contact. No, he didn't. He didn't make a claim. He didn't testify, remember? In your head, you can do whatever you want. Well, it doesn't make any sense because what you're saying doesn't make sense. So, okay. I was just trying to point out that what you're saying doesn't make legal sense. So, yeah, I suppose in your heart, in your head, you can say, my verdict is blue for all the good it will do you. I don't know what that means, but, you know, your verdict is blue. Okay, great. How's deliberation work? Well, the deliberation's in secret, so I don't know exactly how that works. They'll go into a room and yell at each other for a while. Probably give speeches or something. I don't know. I don't know if their votes are public or not either, incidentally. I don't know how that works. Maybe they're taking a secret vote in addition to the secret deliberations. Could be interesting. Plausible deniability, right? It allows someone to vote guilty and be like, of course I voted not guilty. So maybe the vote's in secret. I don't actually know. I don't know when they vote. I don't know if there's a time limit on deliberations under the rules. I'd have to double check. I don't think so. I don't think there's a time limit for the deliberations, but I'd have to double check. Jones says they have not proven in the UK. Well, Lottie freaking da. We're not in the UK. Yeah, I know you have it in Scotland at least. It's just not a thing in the United States. So, you know, I don't know. Maybe in the UK you can vote for tea and crumpets. I don't know. You have guilty, not proven, and tea and crumpets. and balderdash at the Tower of London. I don't know. Maybe that's a verdict in the UK. I don't know how you do things in your crazy backward system over there in the UK. Can't intelligently speak to that. Well, with my friends, I think we will end it here because nothing is obviously going to happen in the next 10 minutes. And if it does, well, you know, we can't cover it anyway. So we will end here. We may be on tomorrow. We'll see how it goes, but yeah. But nothing's happening, so we'll end the verdict and the stream. So I've enjoyed this. I hope you have too. I hope you've learned something. And we'll see how it all pans out in the end. I've been Uncivil Law. Until later, my friends, I hope all is well. Cheers, my friends, and for now, goodbye.